There's Dave bringing his excellent palm tree ventilation with him.
Hello, everybody.
Linda texted me. Did Turkey come in today?
Yeah.
Right now. Oh, shoot. Yep, now.
To be honest, I wouldn't mind if she calls in to him, so we know.
Well, I'm gonna text her and say no. Are you going to call?
Yeah, egg her, get her.
Well, Megan, there's Leslie. Hey, Leslie. Is Andrew going to be with us or not tonight? Not. Okay. Stephen Welch is under the weather, so he won't be here. And I know that Campbell had said that she was taking her mom for some medical something off island. I don't know what the boats are doing because the weather's not great. So I think it's possibly time to open the meeting. Greetings, everyone. We're glad to see you. Let me start again by thanking our staff for their hard work in the middle of so much going on. And if you aren't aware, they had to shut down for a couple of days because of some COVID issues there at the Plus office. So we know how hard you've been working and we really appreciate it very much. And Megan, it's a wonder that you keep the day of the meeting. It seems like there's more and more things coming in and you never drop any balls. So thank you very much. I'd like to call the meeting to order and do so by taking attendance. First board members, Fritz McClure.
Aye.
John Trudell.
Aye.
Nat Lowell.
Aye.
Dave Iverson.
Hi.
Judith Wagner here and Dave Callahan. I see over here. And as I said, I know Stephen Welch is, for those who just joined us, Stephen Welch is not able to be with us because he's under the weather, and I'm not sure about Campbell Sutton. So David Callahan gets to work out tonight. For our staff, Leslie Snell, Megan Trudell, Catherine Ancero. I see all of you. And for speakers, presenters, and representatives, this is just to help us get the minutes straight to begin with this. But Mike, thanks, Catherine. Michael Conley, if you could just show us, say hello so we know your mute on and off works. Unmute if you would, Mike.
Hello.
Hi, Arthur Reed, how's your sound tonight?
I'm here. I hope you can hear me.
We can. Art Gustaro.
Here.
Brooke Meerbergen. I saw him earlier.
He's on mute.
He's on mute. Brooke, you're here, but you're muted. Paul Santos.
Here.
Linda Williams.
Here.
Billy Cassidy.
I'm here.
Jay Maroney,
Here.
Tori Ewing, and there may be others who come in to join us. We'll approve the agenda in a minute, but just to go through the preambles, as I think everybody's well aware at this point, we're operating under the governor's executive order that allows us to meet in this forum and format because of the COVID pandemic. So we ask in particular that you, for members of the audience and presenters, that you ask to be recognized before you speak, and that we all take turns and try to be respectful of each other, because we don't get to see each other in person or to read body language. We just have to work within this two-dimensional virtual space. So for anybody who may be there tuned in on the town's YouTube channel, the beginning of the meeting covers a number of matters that are not ones for which we have public hearings, or not ones that there's an opportunity for public comment. But when the time comes for public hearings and you can speak, Megan Trudell will do an announcement explaining to you how we go about doing that, and that'll be your chance to weigh in if you'd like to do that at that time. As I've said to the board before, in trying to maintain the pace of meetings and to comply with various requirements, the topics where we take up second dwellings and A&R plans, those are ones that are not subject to public hearings, or not ones that our alternates can speak on either. So we're dealing with those as a matter of consent agenda once we get going with the meeting. So that's enough of the preamble. Is there a motion to approve the agenda?
So moved.
Fritz seconded. Roll call, John,
Aye.
Fritz,
Aye.
Nat,
Aye.
Dave Iverson,
Aye.
Judith, aye. We have two sets of minutes, August 7th, 2020. Let's take them one at a time. Were there any corrections? Is there motion to approve?
So moved.
Fritz
Second.
moved. That was Dave seconded. Roll call, Fritz,
Aye.
John,
Aye.
Nat,
Aye.
Dave Iverson,
Aye.
Judith, aye. And then September 28th, 2020, motion to approve.
Aye.
Fritz,
Second.
Dave, okay, roll call, Fritz,
Aye.
John,
Aye.
Nat,
Aye.
Dave Iverson,
Aye.
Judith, aye. Okay, we're ready to proceed with second dwellings. Were there any of these that anyone wanted to take off the consent agenda for discussion? Yes,
Not that I necessarily wanted to take them off. It's just a point of question with respect to most of them.
yes,
And it's really addressed to staff. And in all or almost all cases, it says Conservation Commission approval is not required prior to the issuance of building permit. And I just want to be sure that the Conservation Commission agrees with that statement. And in particular, my reference is simply to the select board's adoption of the
right.
Coastal Resilience Advisory Board's recommendation regarding sea level rise.
That's exactly why that's flagged there, so we know that staff has looked at that and brought to the attention of applicants. Fritz, are you saying you thought there should be further contact with the Concom before including that? I think that's simply to flag for us that in the past, we've sometimes asked questions about, has the Concom looked at this yet?
It's just a general question, because it says approval is not required. And so I'm simply asking whether the Concom agrees that approval is
Oh,
not.
okay. I think that means approval's not required from the planning board, but Megan, could you
Right.
clarify that?
That's what it is.
So
Yeah.
I think my takeaway from our conversation a couple months ago was to take these parameters that other boards have put into place and just, make sure that the applicant's aware that there may or may not be other steps involved prior to the issuance of a building permit. So that question has been added to the application for secondary dwellings, and that's why it's listed in the report, yes or no, based upon what they've selected on their application.
Thank you.
Fritz, is
Right.
there a way you would prefer to see it listed, or you think is a clear way to list it?
I just want to make sure that we're not, that, I don't know how to say this. I just want to make sure that staff is not opining to us that the Concom has opined that their approval is not required. That's all.
Okay. Thank you. And also, I'm sure we don't want to give the applicants a misunderstanding that they would then come back and say, well, the planning board or the planning staff told us something, right?
Correct.
Matt, did you have a comment? Or-
Me? No. Oh, I'm sorry.
Dave,
Judith?
yes.
Oh.
Leslie,
Yeah, so our comment in the staff report is based on, the plan that's provided and whether or not the proposed work for the second dwelling is shown to be within the 100-foot buffer or not. So that's what that comment is based on.
okay, everybody clear on that? Any other questions or comments about that point? Does anybody need to recuse for any of the second dwelling matters?
I have a question on one if I could.
Yes, Dave.
And maybe Brooke's the one to answer this. It's on 36 Somerset. Just
If it's okay with you, Dave, if you want to talk about that one, let's just pull that off the consent agenda and then we can delve into that directly. Is that all right?
yeah, I mean, it's just a question about the second driveway, whether it's going to stand, whether they're going to get rid of it, if it functions.
Right. Before I'd read, just for the simplicity of the procedural stuff and the note taker, let's take that. I had a question similar to that on that one too, Dave. So let's pull that off the consent agenda and ask, is there a motion to approve the rest of the listed second dwellings?
I'll make the motion.
John, is there a second?
Second.
Okay, I don't know if I need to read these, but it's PBDW 2020-11-59, Jacqueline and Robert Burke, 2020-11-60, Kimberly Kania, 2020-11-1, we're holding over for a minute, 2020-11-62, James Koval and Natalia Tarasova, 2020-63, Matthew and Teresa Stone, 2020-11-64, Stephen and Carrie Phillip, 2020-11-65, Pharaoh Strada, LLC, 2020-11-66, Christopher J. McGee, 2020-11-67, David Silva. So that's the set that we're about to act on. We had a motion in a second. Is there further discussion? If not, I'll take a roll call vote. Fritz,
Aye.
John,
Aye.
Nat,
Aye.
Dave,
Aye.
Judith, aye. Okay, going back now to 2020-11-61, David Engelstrow and Heather Lindley, 36 Somerset Road. Brooke, thank you for being here. And have I confused us enough that the question needs to be repeated?
No, I think I understand. My client purchased this property in 2015. That second driveway, it's more of just an area where someone had, repeatedly driven over the dirt and created two little wheel tracks. And that predated his purchase of that property. And I think it first started appearing in according to the GIS map around 2007. And so we would like to keep it because he's got a shed over there now and doesn't want to drive across his yard to get to the shed.
Okay, Dave Iverson, did you have additional questions?
No, it wasn't clear to me whether they wanted to keep it or not. It says it's gravel parking. So I wasn't clear.
That second driveway is just two dirt tracks in the grass.
Okay, if further questions on that one? If not, is there a motion to approve?
I'll make that motion.
Dave
Second.
moves,
Second.
Nat seconds, roll call vote, Dave,
Aye.
Nat,
Aye.
John,
Aye.
Fritz, Judith, aye. Okay, done with second dwellings.
Thank you.
Thank you, Brooke. I think you've got another one, so you're
I do.
sticking around, right?
Yep.
A&R plans. We've got 3 here that are tied in with a public hearing, but are there any that anyone needs to recuse about? Are there any that anyone wants to take off the consent agenda? Okay, is there a motion to address the following 2020-11-102 Jean-Francois Formela, 2020-11-103 Karen Alper Revocable Trust of 2005, 2020-11-104 90 North Liberty Preservation Trust, 2020-11-107 Norris Building Company, Inc., and I'm sorry, that's all at this point. Is there a motion to approve those?
So moved.
Second.
Okay, I think that was John moved, Fritz seconded, and Nat was in there by the nose, probably before or
All
after.
good.
Take roll call on this, Fritz,
Aye.
John,
Aye.
Nat,
Aye.
Dave,
Aye.
Judith, aye. Okay, and then we need to simply be aware that there's 3 more. I don't think we have to do anything about that now. We're going to have to deal with those when we do the public hearing. Right, Megan? And then I think the next item is previous plans number 7972 Woodland Hill, modification number 3. Megan, would you like to say something about that?
Yeah, I think because of the reasons listed in the staff report, the applicant has requested to carry this over to December. They're not quite ready to ask for that release just yet.
Okay, that's good because we would have asked about that. So, all right, is there a motion to continue that till the December 14th meeting?
So moved. Second.
John moved, Fritz seconded, roll call, Dave,
Aye.
Nat,
Aye.
John,
Aye.
Fritz,
Aye.
Judith, aye. Okay, then we have public hearings. First of these, PLSP 2020-08-66, Great Lady Marine, MCD amendment number 213 Arrowhead Drive, request to continue till January 11th, 2021. I guess, and I'm going to take PLS, well, let me take them one at a time. Is there a motion to continue?
Motion to continue
John,
till January 11th, 2021.
Second.
Dave seconded, roll call.
David's question, Callahan.
Just a question.
Yes, please, sorry.
The question was simply, has the deadline date been extended or will it be extended?
I just saw that. Thank you, Fritz. The deadline date is December 13th.
It will be if it needs to be. The property is it's under contract right now, so it might be requested to be withdrawn. Either way, I suppose it'll have to be extended. So I'll get that from the applicant.
David Callahan, did you have your hand up? No, okay. I think we had a motion that was John and seconded by Dave, is that right?
Correct.
To continue till January 11th, 2021. Roll call, John,
Aye.
Nat,
Aye.
Dave,
Aye.
Fritz,
Aye.
Judith, aye. Next one is a request to withdraw. Megan, this is PLSP 2020-09-70 Donald and Ulwin Pond Grace 78 Pulpus Road. That people will remember that. This is a request to withdraw. Is it permanently, or I guess I'm doing my legal thinking about, is this with prejudice, or are they going to come back and start again, or what do we know about this?
I think they just they've requested to withdraw at this time, so they haven't really provided me with an explanation as to why. So for that reason, I would suggest without prejudice, just to give them the opportunity to come back if they choose to do so in the future.
Okay, so
Yeah.
do we need to act on that?
No, because it's not a decision being rendered, it's just a withdrawal.
Okay, so we're just going to allow that withdrawal, and then PLSP 2020-07-56 Atlantic Landscaping Inc. 6 and 8 Marble Way, request to continue until December 14, 2020. I'd like a little, if you don't mind, making a little more explanation on this. You'll remember this is arising in the context of an enforcement action.
Madam Chair?
Yes.
Point of order.
Yes.
Before we discuss, I would like to recuse myself from this.
Okay.
So I think just because you're going to ask for an explanation, I think I should recuse now.
Okay. Thank you, John.
Sure.
You're recused. I just want to be sure everybody knows which one we're talking about. And I know, Megan, I think that Leslie met with their counsel too. So just a little bit of an update of where we sit with that. They'll be back in December, is that right?
Yes, I know that Leslie had discussed some options to move forward with the applicant's attorney. They in turn needed some time to discuss that with the applicant and involve any engineers, surveyors, that sort of thing, to make the necessary adjustments to get back to the board. So that's why they're requesting to come back to supply you guys with some new information next month.
Okay, and there's been a lot of people attending to speak to that, so just be sure they need to know that they get it in on time, so there's ample chance for people in the neighborhood to review if they want to speak before us again. And as we get into the holidays, it's harder for people to keep track of some of those things. Okay, so I need a motion to continue.
So moved.
Do I need to activate David Callahan on this? Are you feeling active, David?
Well, I think you might as well, because I know Stephen Welch has recused as an alternate from this.
And,
Campbell would have to pull it in now anyhow, I believe. So,
okay, so David, you'll be seeing this again, so you're activated. Roll call to continue this until December 14th. Who made the motion to do that?
I did.
Nat?
I did, yes.
Who seconded?
I did, Fritz.
Fritz, okay. Nat,
Aye.
Fritz,
Aye.
Dave,
Aye.
David Callahan,
Aye.
Judith, aye. Thank you. Okay, Megan, this might be the time. The next item is one there may be public here to observe this or speak. It's PLSP 2020-06-52 and 2020-06-70 Coffin Family Nominee Trust, Shirley Louise Coffin, Spencer Trustee, 31 Fairgrounds Road. Would you say the blessing, Megan, and explain to people how they, if they want to speak, what they need to do when we get to that part of the discussion?
Sure. So for those watching at home that have not registered and wish to participate, there should be a link at the bottom of the YouTube screen where you can enter your information and then become an attendee of the meeting to participate in the webinar. Otherwise, there is a link posted on the agenda through the town's website. The board will typically discuss amongst themselves and with the applicant when the chair opens the floor to public comment. If you could please use the raise hand feature and I will acknowledge you in the order that you raised your hand. I know there might be some people attending as panelists for different applications, so that holds true to you as well. If you could please use the raised hand feature to be recognized if you are not a board member or an applicant in the discussion.
Thank you, Megan. Okay, Arthur Reed, Art Gasparo, would one of you like to kick us off with any updates of further information you provided?
Sure. I'm happy to go first. For the applicant, Art Gasparo, we provided some additional information to the board. I submitted a letter and revised set of plans, and we'd like to briefly go over those with you. We believe that we've made substantial revisions based on the input that we received from all of you at the last meeting. The project remains essentially the same as what has been discussed in the previous hearings. What has been revised is the driveway and parking layout, and much with your input, I modified the driveway and the turning area to create a wider aisle through there and separate the parking to be on both sides of the one-way driveway through there. So we've eliminated all of the stacked parking spaces. We've also added or clarified 3 ADA van accessible spaces and moved those from the ends of the parking areas to the central area. You'll notice that I also placed the areas with the X, if you will, which would be the van accessible spot, such that they align to create a corridor for pedestrians to move from the north side to the south side, the different houses. And we added an ADA compliant sidewalk along both parking areas along the outside, so you get out of your vehicle and be able to get on a sidewalk, all of which I believe were suggestions from the board. We slightly moved the loading zone. You can see that I've put that towards the exit driveway, essentially right next to where the screened dumpster would be. I believe that spot works well, and that could be ultimately for UPS type vehicles, fuel deliveries, trash, all of that, and stay out of the aisle. And we also improved the landscape plan, revised the landscape plan. We added the berm along the back property line that had been suggested, though I will note that I included a note that said the berm would be placed where it wouldn't negatively affect or impact existing mature vegetation. So we're trying to strike a balance there between, typically to construct a berm, you would essentially have to disturb a full area. And again, what we've been striving for and looking and committed to do for these areas is to create a dense screened buffer to vegetated buffer to the adjacent property owners. So where the vegetation is not dense, we could put a berm. We've added some additional language to the landscape plan that the understory would also be planted. And we've added a board fence along that rear property line as well. And I believe with that is essentially the changes that have been made. And we've I'd be happy to address any questions or concerns that you may have.
Thank you, Art. Arthur, did you have anything you want to add at this time?
Nothing more to add. Obviously happy to answer any questions.
Thank you. Megan, anything you want to say?
No, I think Art did a great job of presenting the new materials that have been submitted based upon feedback given.
Okay. Board members, anybody with a question or comment, particularly a question to the applicant before we open the public hearing to public?
Yeah.
Fritz, yes.
Yeah, at the last meeting, I had raised some issues regarding maintenance, ongoing maintenance, and specifically the endowment for, or if you want to call it an endowment, that's what it's referred to in the decision, draft decision. Maintenance reserve for roadways, drainage, and so forth. This is something we've been particularly concerned about in the past. I've noted that there has been submitted a Common Rental Association rules and regulations. I didn't see that addressed in any of this. And so I guess what I'm saying is in the draft decision, unless there are other supporting documents that I'm just missing or have missed, is it simply says that the association will endow at the rate of $1,000 per unit initially. There's no follow-up. There's no suggestion or requirement as to what will happen in the future. And specifically, I think I said that I would be looking for some requirement for an ongoing payment into that fund based upon some percentage, presumably more than 100% of the initial or anticipated expenses for that, similar to what you would have if you were doing condominium documents and you had to come up with a condominium association budget as to what you were going to put there. So I don't see that addressed.
That sounds like an Arthur Reed
Yeah.
question.
Yes, to answer Fritz's question on that, the way that we would see that going is the way that's typically handled on subdivisions, in which at the time of the endorsement of the plan, there will also be the approval and endorsement by the planning board of the documents, and that should be called out in the, I think it's called out in the decision, and if not, it should be, that specifically requires there to be a homeowners association and makes provision in there for the homeowners association to be able to make assessments against the various lot owners. And also there's the endowment and the endowment agreement that's made between the subdivider and the planning board, which requires the initial endowment and also requires ongoing payments as necessary to maintain the infrastructure of the subdivision. And typically the exact documentation on that would be presented at that meeting at which the plan would be endorsed and all those documents would be approved.
Arthur, just for clarification, is there some standard practice here about how the amount is calibrated when you're dealing with something with stormwater issues and water issues particularly? You may have some multiplier about what you anticipate increases from one year to the next, kind of the reverse of depreciation or something like that.
That normally hasn't been handled that way because it's the obligation of the owners. In this case, it's contemplated as being a rental project, and as such, there would be only one owner, but that one owner would have the responsibility on an ongoing basis to maintain the infrastructure of the subdivision. that would all be called out in the in the document. I'm not aware of there being any specific formula for that, other than that there's an initial nominal sum that is required to be contributed to the association for each lot, and then on an ongoing basis, whatever the costs are, the owners, or in the case of one owner, the owner has to pony up whatever is necessary to keep the project maintained.
Is there any kind of bonding way of having bonding to be sure that we all know with real estate, people may be an owner and then they may run into financial difficulties in the future, or they may sell to somebody else who's not on the scene now, and whoever that might be might not be as a solid citizen in handling things like that. I'm mostly just asking what pattern and practice there is here.
I have not seen that done.
Okay.
Madam Chair, if I may just echo on Arthur's perspective on that. Typically in a home ownership situation, it would be handled through the HOA. In a rental situation, it would be directly handled through the owners of that rental.
And there would be specifically the maintenance agreement that would be in place that would require, as I say, whether it's an association of many people or an association of one, that association has the responsibility to maintain and therefore to raise the money to do it.
Thank you. Fritz, did you have follow-up?
Yes, I respectfully, I understand, Arthur, what you're saying. I think in this and I understand certainly in the case of a homeowners association, you have a right of assessment. But in this particular case, you're dealing with a rental property with an owner, and that owner may change. And I think we should be requiring some specificity as to what that ongoing maintenance requirement will be, and presumably, perhaps, not presumably, but perhaps something even akin to a budget like you're quite aware of in a condominium association, a budget with reserves and amortization would have to be provided. For me, that would be a requirement to be included in this decision.
Okay, are there other questions? Arthur, did you want to respond further, or I think you heard Councilor McClure's observations? Anything else you want to say at this point?
Not really. I mean, I heard what Fritz had to say, and I understand the point perfectly. I do think that the language in the document that will be presented and then reviewed and ultimately approved by the planning board should be drafted such as to enable covering that.
Thank you. Are there other questions or comments from the board? Nat?
You talking about just anything on the project at all, Judith? Is that what we're?
Before we go into
Just any specifics? Yeah, no, that's fine. I just, yeah, let's wait for the public and then we can come back around, I think.
Okay, I just want to be sure anybody who wants to.
I mean, that's my opinion.
Okay. Dave, John?
I'll wait for a public comment. Thank you.
Okay. Megan, if you would see if there's anybody in the public who would like to speak, this is to follow the instructions that Megan provided previously in terms of using the raise your hand function. Just to remind everybody, as you know, we've had multiple occasions to hear from the public, so don't feel that you need to reiterate everything you've said if you've spoken in the past, because we're very familiar with that. We've done our homework and we are paying attention to that. So, and also just because of, again, I'm just trying to deal with the Zoom dimension here. You need to address any questions or comments to me, and I'll ask the appropriate staff or the applicant to respond rather than having you start to interact directly with those folks. And I'm going to assume that most people are able and willing to give their comments if they're recognized once. So this is not going to be go around and keep saying the same thing on multiple occasions. We're just out of mutual respect for each other and other people who are here to speak to matters later in the agenda. We try to give everybody a fair chance to speak, but we also ask you to be reasonable and work with us, that if you have comments to offer, that you do that at the time you first step up, rather than assuming that you're going to come back for 3 or 4 or multiple times. That's not out of disrespect for you. That's intended to be out of respect for everybody who may be here to express their views. I hope you understand that. Megan, are there speakers who'd like to address the board?
Yes, so first we have Val Oliver, followed by Jerry Vigil. Val, you're on as a panelist, so you should be able to just unmute yourself.
And could I just say, for anybody who, it would help us to know if you're going to comment about the implications for you personally, to let us know if you're living nearby or anything else about the context that your comments are coming from, so we can evaluate what you're telling us, okay? We'd appreciate that. Thank you. Ms. Oliver.
Hi, can you hear me?
Yes.
Okay, thank you. I am a Mid-Island resident. I actually live on Newtown Road, so I'm commenting as a person who lives in the area. My main concern still remains cars and parking, but I did have a question that I really couldn't find an answer for, and that was, are these in fact year-round rentals? I wasn't clear on that. And then having read through the document, the rental association agreement, I had a little bit of concern by the wording on some of the line items. One, the failure to vacate by noon clause. That language makes me think is more pertinent to a short-term rental situation rather than a year-round long-term. In addition, the guest clause that refers to the host, adult resident, and guests staying more than 14 days have to be signed on the lease as a roommate means that you aren't limiting the amount of people per bedroom, which then immediately spills into parking for me. And the parking assignments are based in that document on 1 space per bedroom, which is sort of contradictory to the guest clause. And I guess the offer is that people can park behind the public safety building, which kind of validates my concern all the way around. So it's parking in cars mostly. And I also wanted to know, there was mention several times of the management office, but it's not indicated on the plan anywhere. And I wondered, is that going to be on site?
Okay, to just summarize and then see if anybody from the applicant wants to respond. I would have to tell you, Ms. Oliver, that I used to teach property law for 30-something years, and that's a pretty standard set of rental provisions about things like somebody's boyfriend comes and, or girlfriend, or somebody comes and starts to pile on with added family members. So I think that that's a fairly standard form, is what I would guess, if that's of any help to you, but the applicant can respond in more detail. You asked about whether, I think your first question was whether this was going to be limited to year-round Nantucketers. That's something I think the applicant can respond to. I don't think that when you're looking at a planning approval, that's something that we have authority to control, but they may have further comments on that. And then other things about the amount of parking, if they have things they'd like to say to that. I think those were your major points.
Yeah.
would Arthur and Art, would you care to comment now, or do you want to save these up and comment when we have more in the queue?
I can comment on specifically the principal point there, which is, yes, this is intended to be year-round rental for Nantucket residents. It doesn't lend itself in the nature of this project to short-term rentals. And in any event, the language, as the chair just pointed out, is typical language that any landlord will put in a lease in order to maintain control so that tenant situations don't get out of hand. And nothing in there would indicate that there's any intention other than having the documentary framework to run a tight ship.
Then I think you said, Megan, Mr. Vigil's next up, is that right? Mr. Vigil, welcome back.
Hello, how are you?
Good,
I
and
read
I just wanted to say, I understand you sent in additional comments this afternoon, and just wanted to assure you that Megan distributed them to the board.
Thank you. Okay, basically I went over the revised plan that Arthur talked about, and I still have concerns. The first thing that people haven't really spoke about is any consideration for having the complex less dense than it is. Nobody's really talked about that. And I think if it were less dense, that a lot of issues that are there now, would be reduced. And as far as the maintenance, I concur with Fritz about all the concerns there. And a couple of them that I have is mentioned in the application that there would be a provision for irrigation for the landscaping. However, it's not clear if there's going to be an irrigation system put in, or if it's going to be done by the landscaper that the owner would hire. Also, and I'm concerned about the buffer using shrubs adjacent to our property. I'd rather see what they're going to do on Fairgrounds Road, which would be with the arborvitae trees. I think would be make a more appropriate barrier or buffer for the abutters, not only myself, but others in the neighborhood. And one consideration that I have is that it appears that on the exit drive, that there is no buffer shown on its landscape drawing, which is extremely disconcerting for the abutter at 37 Fairgrounds, which is the Tedeschi's. And, I've talked to various neighbors of mine, abutters, and they share the concerns that I have. And the other thing is Arthur mentioned that he adjusted the unloading dock, so to speak, for various people like UPS or FedEx or the garbage people, and it doesn't seem practical as far as for UPS. I mean, as a UPS driver, to park in a loading area and then have to walk all that distance. I think realistically that may not occur, that the UPS driver may take an open parking space inappropriately and, deliver things, which could be a problem. Then the other thing that I want to mention is that the area of public safety is still a concern. with the one-way driveway, a 12-foot wide driveway, and God forbid if there's a fire and if the fire trucks and emergency vehicles have to come in, it could be very difficult for the hook and ladder truck to extend their ladders to a building that's on fire when there's cars in the parked areas, based on the plan that they have. And, you know, that's pretty much my concerns. And, you know, I really would like the board to really look at this seriously and make some decisions that will be appropriate and for everyone concerned. Thank you.
Thank you, Mr. Vigil. You made a number of points I could try to summarize, but I see Art Gasparo making notes, so maybe you have things you want to respond to individual aspects of that. Do you?
Yes,
or do you
Madam
want
Chair,
me to-
I would be very
Yeah.
happy to.
Thank you.
And I'm happy to really, I think some of them are simply clarifications.
Thank you.
Is starting with the density, again, being, you know, I think what has to be factored in here is that it is a flex development and we're preserving a large amount of open space. And so the density is what is permitted. We haven't actually applied for as many units as we possibly could. And I think we also demonstrated through the proof plan that if this was to be developed under the conventional subdivision rules, that the density would likely be even greater. So we believe that the density proposed is fully in keeping with the bylaw and meets all of the required standards. The arborvitae, we agree with Mr. Vigil, and shown, I'm sure it's not clear because of all the different symbols, but I actually was very specific to show the green arborvitaes that he mentioned all along his property line. So you'll note that I added it's that same symbol that's shown in the plant key, and in the plant key it's labeled green giant arborvitaes. And so while we did add a note about the shrubs, the idea was that the shrubs would be sort of your infill and lower understory in some cases, again, trying to create a more naturalized look and through that area. But that absolutely was the intent. And I can't speak to a commitment to irrigation. However, I do believe that it would be likely that if there was an investment in this level of landscape and trees, it's very likely that you know, green areas on a development like this would be irrigated. The fire truck, again, we ran and included the turning analysis plan for the vehicle that is exactly the ladder truck owned by the Nantucket Fire Department. But also I'd bring to your attention that we've widened that aisle. So in order to have the backup spaces, before we were at, I think, a 12, maybe 14 foot aisle, mostly 12 going around that circle, semicircle. And now you've got a much wider aisle that allows for the backing out of the opposing spaces. And so that just provides even greater flexibility for the emergency vehicle access through the site. And with respect to the loading zone, I believe that it'll work. There's a sidewalk now that leads right from there over. I think that you would expect that a delivery to this area would park, and not all that different than deliveries in the downtown area where they park and sort of spider out to where they have to go. The distance from the loading zone to the furthest structure is a little over 150 feet. So I mean, it's not, I don't think, in any way unreasonable or not to be expected that that's where, you know, they would stage to do deliveries throughout the complex. And further, I don't believe it's likely that a UPS truck is going to pull into a 9x20 parking space. So I respect and understand Mr. Vigil's concerns. I do believe that we have appropriately addressed them all. And with respect to some of the comments by Ms. Oliver, I would say that, again, we have provided more than one parking space per bedroom. There is a surplus of spaces. So we're in excess of what is required. And the one thing that I neglected to mention in my initial presentation, which I thank her for reminding me, was of the extent, as well as Mr. McClure, the extensive document that we also included with respect to the management of the association, rules and regulations. This is going to be that's going to be conditioned to have that, those rules. As a tenant, you're going to have to accept them, and it's going to be, that's going to be your check and balance right there on a good operation. Thank you.
Megan, is there other people in the queue?
You might want to give a second or two, but I'm not seeing anyone raising their hand. Remember, if you wish to participate, you need to use the raise hand feature so that you may be recognized. Not seeing
Okay.
any.
All right, then.
Billy Cassidy is raising his hand.
Okay, Mr. Cassidy, good evening.
Madam Chair, through you, if I may address Fritz.
Please.
I just wanted to make it clear that we have no issue whatsoever with his concerns. And I feel personally that I share that concern and they will be addressed. I am not going to speak to how Arthur creates that document or the timing of it or what have you, but there is nothing offensive in any of what was mentioned, and I embrace that. And that's it. Thank you.
Thank you. Anybody else who hasn't spoken? Okay, I'm going to turn to the board now. I think we probably will close the hearing at some point here, but I'll leave it open at this point in case the board wants to pursue anything with those who've spoken. Who'd like to go first? I have one question, Megan, just for the record, if you don't mind. I wrote you this question before others may have it, but with the changes in the layout of the roadway in and that kind of thing, I know the applicant submitted to the fire department for further clarification whether the turning radius was adequate. And I think as of this afternoon, you hadn't heard anything else back, but they had previously approved it as not a problem. Could you just clarify that if you don't mind?
Yeah, sure. So, of course, before any filing of a decision, we would need to formally have their approval. That said, Art has used the proper softwares to determine that it shouldn't be an issue. I don't anticipate the fire department having negative feedback on the updated plans. And I think it would be entirely okay to proceed on the condition that we do receive that formal approval from the fire department, but I don't anticipate it being any issue.
Okay, thank you. Did I see Nat or John? John.
Well, Madam Chair, obviously we've been speaking with this for months now in many meetings. I would like to compliment the developer for hearing and trying to apply everything and listening well to what we've been asking for. There are some points that other board members have made, and I don't want to be redundant, but I'll just go over a couple. Management plan is something that has come up constantly. The maintenance plan, and maybe even the maintenance or the landscaping plan, any kind of fees that are associated with that to make sure there's enough in the bank, so to speak, to make sure that proper maintenance be performed. The fire department, if they're okay with the turning ratio and things, I don't have an issue with that. I'm not going to tell the fire department what they do and know as being experts in the field. So if they're comfortable, obviously I'm comfortable. The density, obviously we as the board have to kind of control it, but it is a flex. And I know that the developer has reduced it from the original. I believe they had 6 buildings. So although it's not as less dense as we would like, there has been a modification. It's a flex. It's not a 40B. And I say that because I would love to have more affordable. However, not just more houses. And I wish there was some way to mandate to make it just so it's not just a free market and maybe going to the people that don't necessarily need it. But I understand where we are with that. And I hope that the market dictates that for the affordability. So we actually hit the demand of who really needs these units. And as far as the management plan, I've seen this in many neighborhoods and as far as committees. So maybe from the management plan, there are people within the actual neighborhood that live in the development that would be part of the plan being on a committee. Maybe there's a maintenance committee, maybe there's a landscape committee. And also because they would have a vested interest in where they live, but also maybe there's an at-large position from maybe a member that lives in the surrounding neighborhood that might have some criticism that is good and bad. So that's just a thought. I don't know if we've discussed that at all, and it's obviously not mandated, but it's just a suggestion. So I've been really one of the sticklers for me throughout this decision has been parking, and I know it's been modified many times. I do actually like this plan much better. I know nothing is ever going to be perfect, but I really was opposed to the stack parking, and I'm really glad we were able to see a new plan. Thank you, Art, for designing this. And I wish I could say it's 100%, but I still have a couple of concerns. I see where the ADA compliant parking is, and one of the things that comes up, and maybe staff can help out with this, is access to the actual 5 buildings. If you were, pretending there was a car parked in every space on both sides, not so much worried about the fire truck going through, but just getting out of your car and having easy access. People do unload things and just to find a space to get to their unit there. I don't necessarily see a clear path or sidewalk or something, and I'm sure there will be some kind of tweaks and sidewalks that are open for you to get through. If you did use the ADA compliant space that you're not allowed to park in so that you can unload in, that would give a little convenience towards unloading things. But I don't see really towards the far left unit, how would you get access to that? So it's not 100%, it's absolutely much better than originally proposed and modified. So I do appreciate the changes and the willingness of the developer to meet the demands and the concerns of the surrounding neighbors. And I don't know if everyone is going to be happy or 100% on board, but I think this was a remarkable improvement. And as I said, for the record, I would like to see more affordable housing, not just more buildings. But I'm really hopeful that the market will dictate this. But thank you.
Thank you, John. Others on the board?
I'll say a few things. Just a couple of issues. I agree with what John said about the parking for sure. And that little backup area there, that's a good point. So the front, all right, the sidewalk, we talked about that. The bus stop, the front of the property. I mean, I don't know where we sort of stand with that, but I'd certainly like to see a sidewalk, at least on this property that would later connect from Tedeschi's to Trotta's at some point, or I'm not sure exactly where we left off with that. I know we discussed it once, 2 meetings ago, I believe. There will be eventually a MUP path to Newtown from Old South, but since we're moving the bus stop and, it's just inevitable that there's going to be a sidewalk needed on that side of the road. you know, piece by piece at some point. So I thought I would bring that back up again. And the sheds, the shed issue, this may be a question for Leslie. I'm not sure on the flex development, but we don't want to make it so that they can't have to come back to us to lift some kind of, you know, agreement in this, you know, approval to not have sheds. You know what I mean? Like, you want to be able to have some kind of shed built, you know, for each unit, or a couple for each unit, or at some point over time, like we did out there at that other place where we had to lift that restriction. What do you think about that, Leslie?
Leslie?
Madam Chair, so, you know, there can be language in the decision that says if they want to add those in the future, they can come back for site plan review without a public hearing. I think that would be appropriate. I mean, the Wrights Landing decision had, and that's what Nat was referring to. That had really specific language because of ground cover and other things out there. It may not be applicable here, but I do think if that's something you want to consider adding or allowing them to add in the future, you should at least give it a cursory review. And just while I have the screen, I guess, I'll point out that the sidewalk issue that you brought up for trotters is in the decision. So there's a really wide right of way there. And there's a condition that says they have to seek approval to construct that.
Okay, great. I knew we had the right of way. I just couldn't remember the conversation, Leslie, verbatim.
Thanks, Nat.
Thank you.
Let's see, Dave or Fritz?
I think I've made my comments, and I'll reserve just a final comment before we vote. Dave, you want to go ahead?
Yeah, I mean, I think I've said everything I really have to say. I think Fritz's comments are important. Everyone's comments are important that should be followed up on. But other than that, I mean, I really appreciate what the developer and Art have done to try to address people's concerns. And I personally think that this is better than what it would be as a 7-lot subdivision. So that's about all I got.
David Callahan, did you want to say anything?
Sure. I appreciate the developers, marking and getting rid of the double parking, et cetera. It's probably still a little denser than the neighbors or I would like, but I think it's something that's passable through the laws that we have, that we work with, and maybe that we need to change some of that open space determination to make it even larger so it can't be as dense in the future, but not for this. I would like to see if the developer would like to add year-round housing, not affordable housing, but year-round housing into his management plan, just so that it stays that way, and it would be that way into the future if it was sold somewhere down the road. And otherwise, I think they've done a good job. I like the revisions they did.
Leslie, do you have comments on that? I think, David, you were inviting them to consider doing that themselves, not that we would require it, right?
I didn't know that we could require it. If we could, then it wouldn't be a suggestion. But
I just wanted to be clear on that. Sometimes it's hard to hear all the nuance here.
Yep, I hear you.
Fritz, I think it's back to you.
Yeah.
And I think the next thing would be a motion to close the public hearing.
Yeah. Assuming for the moment that we're prepared to close on this matter tonight, I just want to make sure that we're clear about what additional documentation or additional approvals from us may be required. And just, I'm a lawyer, so I just want to make sure I understand where we're going. And you understand where I'm coming from. I trust Billy Cassidy, Arthur Reed, Art Gasparo. I just want to make sure that all of our comments, and especially my comments regarding specifically the maintenance fund, and I guess I would reiterate Val Oliver's concern about the designation of the management office and where it's going to be and how it's going to be staffed and that type of thing gets taken care of and does get incorporated into, I guess, what will be the decision. And so subject to an understanding as to how that will happen, or that it will, I mean, again, I don't know completely the process as to whether it's like the decision itself will be subject to a further agreement, but it seems to me we're approving the process and we ought to be trying to understand as much as we're approving, but subject to a gentleman's agreement, I guess, with Bill and Arthur and Art, that my concerns and Val's concerns and the other concerns expressed will be incorporated in the final documentation. I'm prepared to proceed.
Thank you, Fritz. Good points. Arthur? You're muted.
Yeah, I'm trying to unmute. Am I unmuted now?
Yes, you are.
Okay, good. That really is covered, at least in practice, by paragraph 3 of the conditions in the decision, that recorded copies of all legal documents, such as homeowners association covenant, statement of conditions, grant of right of enforcement, road maintenance and endowment agreement, stormwater operation and management plan, open space management plan, utility, drainage, easements, and all deed restrictions, including the conservation restriction of open space parcels, shall be presented to the planning board prior to the release of any building lots and within 6 months from the date of this decision. And 4, that a homeowners association shall be established in the form of a corporation or trust and endowed, so on and so forth. Basically, once again, in practice, what will happen is, as I said, that we will come back in with those documents. And those documents will contain typical provisions as well as any provisions that may be specific to this development that obviously we will submit to the planning staff for review and would then be presented to the board for approval and modification if appropriate at the time that the plan comes in for endorsement.
Thank you, Arthur.
Thank you, Art.
Is there a motion to close the public hearing?
Motion to close.
Thank you. That was motion by John and second by Fritz, I think. Roll call vote. John?
Aye.
Dave?
Aye.
Nat?
Aye.
Fritz?
Aye.
Judith? Aye. Okay, what's your pleasure?
Madam Chair, are we being asked to make a motion to recommend or support the proposal in a draft decision for future endorsement?
Yes, what I was going to ask Leslie and Megan, you've given us a chance to review the draft you had done. There's some places you flagged with highlighter to be filled in and things of that sort. Do you want us to walk through some of that tonight, or do you feel based on the discussion that it'd be appropriate to have a motion in principle approving the project and subject to completion of the draft decision to be reviewed once more at the next meeting? Is that kind of where you were going, John?
It was, Madam Chair.
Leslie, what do you think?
Okay, I mean, I think we have enough information to, complete the decision. The only thing that I would ask is the number in condition number 4 about the ownership association or condo owners association to be endowed at $1,000 per unit. Oh, per unit. Sorry, I thought it said per lot. Okay, I think we're good on that.
I think Fritz would be happy to address that.
Other than that, just real quick, I think the other blanks were, discussed. We drafted this several weeks ago, and you've had quite a bit of discussion, since this was initially circulated. So I think we can finish it up.
Fritz, did you?
One more. Yeah.
Yeah, I did. Just so I circumstances. My assumption that that will be supplemented by future documentation that will require something beyond simply an initial funding of that agreement. If I'm wrong, say something.
I think,
You said yes, I think.
I think, yes.
Yes.
I see Megan with a thought. Megan?
No, it's just, I wanted to remind the board that this is a 2-vote decision. So we have to approve or vote on both the subdivision and the flex development provision. So just as a point of order for that.
Thank you. So the
So,
first,
Madam Chair?
yes, John.
I know we have two motions, one for the subdivision, which requires a majority of 3 out of 5, and the flex development, which is supermajority 4 out of 5. How do we incorporate the support of the draft? Once we make those motions and get those approved, are we then going to have the final to the draft at our next meeting for the final approval of that final proposal?
Leslie.
So if you think you need to review it one final time, you could make a motion to approve the special permit and the subdivision, and then you could vote to endorse the decision at a future meeting, or you could vote to do it all tonight. I mean, if you're not going to do the decision tonight, I would actually recommend that you wait and vote on it all together, just in case you need additional discussion. The public hearing's closed, so that piece of it has, been finalized. But internally, if you need more discussion relative to the decision, then you should probably just wait on all of it.
Well, Madam Chair, through you.
Yes, John.
Leslie, I'm not opposed to having a motion for the two motions this evening. I do want to make sure that things that have been spoken about today get incorporated into the final decision. So obviously we don't have that right now, but I don't want to hold up the developer if we extend another month, because I think we're at that point right now where we can vote and just hold out for the final endorsement of the final when the items that were discussed today are incorporated into that draft. Does that sound unreasonable? Or?
My sense from what you say, John, and just reading everybody's comments and body language is we're ready to approve it, but that we would make the approval subject to a further review based on staff recommendations at the next meeting to, I think you used the word endorse, Leslie, is that to endorse the final documentation developed by the staff. So maybe that's approved the subdivision, and then is the decision really largely about the permit? Leslie?
The decision is it's a single document for the subdivision approval and the special permit approval.
Then, John, where you're going, I think, is to move subject to endorsement at the subsequent meeting, but to move approval tonight subject to an additional endorsement of the detailed documentation at the next meeting.
Correct, and to make a motion, obviously for the two motions for the subdivision and the flex. And with the future final documentation at our next meeting.
Is that clear enough, folks that are having to manage the minutes and everything? Megan, you're looking skeptical. I can't tell.
Oh, nope, I'm jotting down notes.
Jotting notes. Leslie, is that all right with you?
That's fine. I just think if you take the vote tonight, that will foreclose on any substantive discussion about the decision. It would be left to, minor tweaks in language and that sort of thing. So as long as everyone understands that.
I think John is saying he thinks that's where we're at, right? That we're ready to proceed at that level. Right,
yes, okay. It is. I think we've heard enough. We feel confident with the staff. I just want to make sure that everything that we've discussed this evening is included into the final documents.
Okay.
Okay, is there a second, Fritz?
Yeah, I just want to make sure, and I'm not backpedaling at all. I'm just saying, from what I heard from Arthur and what I believe the decision says, insofar as my concerns are, I'm not sure they need to be reflected in the final decision, because I thought Arthur said and agreed that those provisions would be a part of subsequent documentation that would be presented to us and subject to our approval. If that's true,
That's what I heard too.
I'm less concerned about the specifics of the decision itself.
That's what I heard. I see Arthur nodding, Megan
Madam Chair,
nodding.
that was my initial intent, to protect for the final decision. And if I wasn't clear, that was my intent. I
But
agree with you, Fritz.
John, I think what Fritz is saying is that further review of actual documents may not be ready at the next meeting. We'll have the decision document, but some of the other supplemental documentation may need to be seen at a later date, but he's got a firm record now with agreement by council that will happen. So I think we have the assurance you were looking for, Fritz, right?
I could just clarify on that, and not presenting
Yes.
any new evidence. We would wait for the appeal period. We wait for you to file a decision.
Right.
After the appeal period runs, when the time comes for us to be able to present the plan, the subdivision plan in its final form for endorsement, it's at that point that we would come in before the planning board with the whole package of documents for the subdivision, which would contain all the things we've been talking about.
Okay, I think we're clear on this now. So we have John's motion. Is there a second?
Second.
Nat seconds, ready to vote. John,
Aye.
Nat,
Aye.
Dave,
Aye.
Fritz,
Aye.
Judith, aye. Thank you to the public for having been active in expressing your views. I think we've got a better project as a result. And thank you to Billy Cassidy and Art Gasparo and Arthur Reed. All of you did a very fine job in listening to us and working flexibly to try to bring some kind of reasonable conclusion here. And I hope we've been helpful in some of the suggestions you heard from us.
I think extremely so, and we thank you very much.
Madam Chair, if I may, just for a point of clarification, I just want to make it clear, we did vote and we did need to make two motions and technically two votes. I just wanted to make sure that was done in the appropriate way, that we didn't have to make actually two votes, because there was the subdivision vote.
I wondered about that too, John.
Yeah.
Thank you.
So, yeah, if I
Megan
may,
and Leslie, do we need to return to that and vote separately on the subdivision and on the permit?
You don't need to take two different votes, but you just need to make sure that the motion was clear that you were voting on both.
I think it was.
It was.
And we did, the only reason why I say we did have a unanimous vote, because if there wasn't a unanimous, then we would come into play with the
Right.
major
Yeah.
majority, the
Special
super majority.
permits.
So we did have a majority, I mean, a unanimous, so I'm not concerned. I think it was clarified.
Okay, well,
Okay.
onward.
Mr. Chairman,
Yes.
I would just like to say thank you for your time, and everybody was, this was very nice. It was great participation from the board members as well as the neighbors and butters. And thank you very much for your time.
And Billy, would you think your Miss Coffin, Miss Spencer, was she who was with us last time?
Diddy is watching. Diddy is watching, and she is, I believe, I will let her speak for herself later. But I think that this has been, this is a meaningful step for their family, and they're just happy with the result. And I will leave it at that.
Well, and
But
I hope too, some of the suggestions, I think, John, your suggestion about possibly involving some of the neighbors in some of the implementation kind of thing. Good neighbors aren't a one-time thing. You got to keep nourishing the communication. And thank you to Mr. Vigil. I know that was a lot of work, and your colleagues and neighbors and Ms. Oliver and others for all the work you did too. But we try to work hard, but we can only do as good a job as the community helps us do, really. The applicants providing thoughtful and good quality work, and the community holding everybody to be attentive and transparent. So we appreciate all of your help. And the professionalism of all the people who helped make this come to pass. So it's now 5:30. I think I'm going to suggest we keep going rather than taking a break, because if we take a break, it's just that much later when we get done. So on to the next item. Thank you again, Billy, and everybody. Okay, number PLSP 2020-08-62, Tidal Creeks Realty Trust, 1113-1517 Tomahawk Road. I think this is Linda Williams, if I'm not mistaken.
It's me.
Happy Thanksgiving to you.
Happy Thanksgiving, everybody. The only reason we're still here is because you wanted to let, you were okay with it last time, you wanted to let Ed Pesci do his thing. And I put Ed Pesci together with Brian Glowacki, and we're fine with the conditions that Megan has in your staff report. Everything's fine. We got the letter from the water company and he reviewed that as well.
Okay, let me open the public hearing in case there's anybody who'd like to speak to this matter. You've heard, those of you who maybe have been with us earlier, that you need to use the chat feature and raise your hand so Megan can call on you if you'd like to speak to this matter. Dave, were you going to say something? Anybody here? Any comments? Anybody wanting to speak, Megan?
I'm not seeing anyone requesting to participate.
Okay, motion to close. Is that Dave waving, or is that a motion?
But we can close and then I could ask.
Okay, Dave moves.
Yes, I move.
Who seconds?
I'll second. Fritz is second, Judith.
Okay, thank you. Roll call, Dave Iverson.
Aye.
Nat.
Aye.
Fritz.
Aye.
John.
Aye.
Judith, aye. Okay, Dave Iverson, comment.
I just have a question. Is he asking for a waiver on the 20% open space? I thought.
Yes.
And is there a reasoning behind that? Because he's kind of starting from scratch in there, right?
Well, scratch is literally scratch because it's all gone. It was never there. And it was, remember, it was full of boats before. So all of it had been taken out before. And nobody in there really meets the 20% because it's the pit, basically. But he's got the screening in the front and he's leaving the trees and he's going to do what he can to preserve what is in there, but there's nothing in there. It's just open.
Megan, do you want to comment on that? I know we've had discussion about the need for screening in some instances that the applicant may not think it necessary, but the staff does think it's necessary. So I want to be sure we hear from you guys.
And we have screening all the way across the front and down a couple of the sides, and the back is lower than the properties on Old South Road behind it, which are all commercial. So he's already done that green screen thing.
Megan?
I think Leslie wanted to.
Leslie, I'm sorry, Leslie.
Yeah, I just have one point on the screening. I mean, I'm not overly concerned about green open space in this particular area, but I do think that the site should be screened. And I thought what we talked about was a higher fence with the screening that some of the other sites have, maybe more like 6 feet in height. And I just realized what's shown on the plan is a split rail fence with green screen, and I'm not sure what that's gonna do. So
No,
I think you all should.
It's a metal fence. It's a 6-foot metal fence that's already there, chain link fence all the way down. And that split rail that's on the other 2 lots closer to Barry Burn, that's going away. And chain link's going to be run all the way down to Barry Burns with the green screen. He's already started to do that. The split rail was there from the previous guy.
Leslie, how high did you think was needed?
I think the 6 feet is fine. That's consistent with what other properties have installed to hide whatever it is they have going on in their properties. So I think we just need a plan that references that rather than the lower split rail fence.
Absolutely.
So Linda, you agree to?
Oh, absolutely. Yeah,
Okay.
we've had that planned all along.
Megan?
So Madam Chair, through you, I think then I will just update my recommended conditions to be specific about the screening to the 6-foot high chain link fence with the green screen.
That's helpful. It's always good to have things so everybody remembers them. So is there further discussion?
Yes, Madam Chair.
John.
I don't know if we've really talked about the storage unit being used as an office. You know, it is not recommended that it be used as an office or retail for various reasons. Number one, once you start to get into that, you're not treating it as a permanent structure. And if you were, then there would be office, there would be bathroom requirements, there would be parking requirements, there'd be handicap parking, there would be retail parking, and it gets to be a little bit cumbersome in what the requirements would be if you treated any of the storage containers as an office. So I just wanted to reiterate what is in our notes there, that under the bylaws, any of the storage containers are not to be used as an office or retail.
Okay. Well, it's not retail anyway, but that's all right. We won't use it as an office.
Well, if it were sold, you never know what the next person might do. So I think John's just wanting to nail it down, possibly. Right, John?
Yes, Madam Chair.
Okay. So let's see. Further discussion from anybody? We've got Megan's recommendations amended as she just suggested.
Madam Chair?
Yes.
Yeah, so I just want to understand, because staff has clearly said that this site may not be used for office space. Now, I've used this Champion on several occasions in different locations for renting equipment. So I need to understand how they're going to operate without having an office.
If we have to move, we have to do it out of his truck, whatever, out of the hooped barn instead of the containers. That would be something we'd have to work on, or we'll move a shed in there. But I want to make sure that didn't say not to use the site as an office. They said not to use the container as an office. Be very specific about that, because we may move in a small shed. Lord knows the Gilwackies have sheds. Move in a small shed for an office. They just haven't gotten that far yet.
Linda, if that's the case, picking up on both Fritz and John, what about bathroom facilities and things like that? Because if you've got I understand Fritz's point. If somebody's got to take the credit cards or the paperwork or the phone call to reserve or something like that, but if there's going to be somebody based there to receive or distribute the rental stuff, it seems like just for sanitation and humanity, they need a bathroom option. I don't know.
Judith, I don't anticipate somebody being there for 12 hours a day. It's a lot of times it's called in or they reserve the equipment and you meet the person there and hand it to them. And then you sign a lease agreement and you go away again. This isn't a constant in and out, in and out, in and out. If it turns out that we need sanitation, I'm sure they'll deal with a porta potty like a lot of the guys in there have. But that's, I don't believe that's within the purview of the planning board.
That's the
and
health department.
Yeah, it's a health department. We'd have to go through them.
Fritz, do you have further follow-up?
I don't, no, I don't want to try to impose anything or suggest anything that's not within our purview. So I guess I would just ask staff, to the extent that something like an office is not required, is as a matter of practicality required on that spot, on that site, is there anything within our purview that is required?
Leslie.
What I would like to do though, Leslie, what I'd like to do, if it can be put into the decision at this point, is should a separate office be placed on the property, we do not have to come back to you. It's an allowed use by right. And it wouldn't be violating the ground cover. I don't want to have to come back in here to put a shed over there. And so if you could put that into decision that we don't have to come back, that'd be great.
I was actually,
Leslie.
oh, sorry. I was going to suggest that you include a condition that said that the addition of a future office may be done without holding a public hearing. So you would, that's in the decision, people would be notified of it. And then you would look at the scope of it when and if it's proposed and determine, at that point, how you need to move forward. So that way you at least have a preliminary review. I mean, it is an MCD, but the office is a use allowed by right. So I think that's a nice middle ground.
John and Fritz, you raised this. Is that agreeable to you?
It's agreeable the way Leslie states it. I just want to make sure that a container doesn't become an office and then next, where it becomes a temporary and then it becomes a permanent fixture after 20 years and it's being used as an office. And it really kind of circumvents the requirements that were needed for parking and all the other things that I mentioned, and including a bathroom. And that's from the Board of Health. So I don't mind, if Leslie's comfortable with the her statement. If she's comfortable with that, I'm comfortable with that. I just don't want to make a decision that's going to be lasting for years when we really could say, we're fine with the temporary container right now for the year while you're constructing a permanent office. But I don't know what we have as far as in order of conditions to mandate that.
Plus, John, I think that the decision in the conditions says this is particular to Champion Rentals and that it should change hands. I don't think he's going to be doing this 20 years from now, but if it should change hands, it has to come back into the planning board so you can review whatever new owner or new use is going on.
Mm-hmm.
Other comments? John, did we get your issues resolved?
Yeah, I know what it's going to be used for, and I don't have any objection to that. I just want to make sure that we're covered when we make the approval.
Fritz?
I agree with John, and I'm happy with Leslie's comment. I realize this is user specific, but nevertheless, I just have this feeling in the back of my neck that somehow this doesn't work without an office. So I just want to make sure we don't approve something that later on comes back to bother us. That's all I'm saying.
Other comments from anybody? Linda, have we addressed everything you wanted addressed?
Yeah, I think between Ed Pesci and the comments that we got from the board, it's great. We're fine.
Okay. So is there a motion?
Okay, I guess I'll give it a try. I would move what are we doing here?
This is on page 13 of the staff report.
Yeah, okay.
So approve the application with conditions.
Yes, approving the applications with findings, and specifically the four findings that are set forth in the agenda. Do I need to read them? If I do, I will. If not, I won't. And subject to the recommendations, I will call it 6 recommendations. The 5 recommendations set forth, subject to, I believe, screening number 4 to read 6-foot chain length with green screen, if I'm right on that one. And a number 6, which would be that the, well, either however Leslie wants it to read, or that the none of the storage containers would be used as office or retail, just to make sure everybody's clear.
I'll second.
You second, John?
Yes.
Okay, further discussion? Dave, you have a cat or a dog? The dog. Well, greetings. All right, ready for a vote, Fritz?
Aye.
Nat?
Aye.
Dave?
Aye.
John?
Aye.
Judith? Aye.
Thank you.
Okay, thank you.
I'll be back.
You'll be back. Okay, next one is PLSP 2020-09-68, Dervan C. Lewis and Maria Henry Lewis, 6 Marianne Drive. I think this is Brooke.
Hello. So in the previous meeting, I had proposed 9 by 20 spots across the front, as well as one that was stacked down the side. In this, I revised it after the meeting to show 5 9 by 20s and 1 7 by 20 to allow for a 1-foot section on either side for fence to screen. Mr. Gasparo had asked that I also include a surveyed as-built to make sure that the dimensions that I had used were on my site plan reflected the reality of the as-built, and I had provided that to Megan Trudell earlier today. He had also mentioned something about having floor plans for the existing structures and the proposed structure, but I think that this is more about seeing how, seeing if you'll approve the parking, and then letting the building department do what they do, which is to enforce the room count when it goes back through to make sure that we conform to the parking requirements. I hope I've made sense.
I think so. Megan, anything you want to add?
No, I think, Brooke did a great job of explaining the new materials. To remind the board, this is a waiver of the vegetative screening as required for this amount of parking. Instead, they're going to be doing the board fence, and it's a waiver of the curb cut length in itself. So if at a future date, upon review of the bedroom count, he needs to come back, he'll need to come back for a separate waiver, but this is just to apply, allowing that length, full length of the site.
Okay, I'm going to open the public hearing. Ladies and gentlemen who may be out there, if you've just joined us, this is a public hearing on this matter on 6 Marianne Drive. If you'd like to speak, Megan has told you how to get in. You go to the chat, raise your hand, and she will call on you or advise us so I can call on you. Anybody out there?
Art Gasparo has his hand raised.
Art.
Thank you, Madam Chair, and thank you, Brooke, for the updated plans. I would just like to bring to the board's attention that I think this is a very, very important, it may not seem like that big of a deal or much of an application, but it really is. It's a major change for where this board has been in the past, and that you would be essentially approving a curb cut that goes property line to property line. It's the essential paving of an entire front yard. There was a lot of work done some years ago by your staff in enhancing the bylaw regulations to allow for more options for curb cuts and vegetated screening. And this blows all of those right out of the water. And if you allow this, then it's going to become the application that gets pointed to on the next one and the next one to allow parking across the entire frontage of properties so that there can be greater density and more bedrooms allowed. And the finding that is necessary is that this is not contrary to sound traffic safety practices, which I think having continuous lines of vehicles all backing out into the road with no breaks to the next property is contrary. And it's not just historic character of the neighborhood, but it's simply because obviously there's not a huge historic character to Marianne Drive, but there is a general scenic character that if you start to allow complete property line to property line at 54 feet wide of parking spaces is a degradation. In terms of the plan that was requested, and I believe that you absolutely should be requiring for a special permit, it's a current survey. And the plan which was provided just today, and I certainly appreciate it that Brooke sent it to me, from the building department is from 1998, and it shows a single 9x20 or so dirt driveway. So what exists today is all unpermitted. And just because there's been an expansion with no other permits becomes now the basis to allow, well, it's almost what's there now and it's not that much of a change. You're essentially rewarding behavior for not going through proper permitting, for having curb cuts that don't meet your bylaw. And now you're going to go even more and I think set a very, very dangerous and poor precedent. And I hope that you will consider this very carefully. I'm not asking you to reduce what they have, but I don't think that any permitted expansion that goes the entire frontage of the property. And then when you talk about a Belgian block apron that comes 10 foot in, that truly is essentially a paving of the entire frontage of a property. The traffic on this road, because of the density and because of the on-street parking, which is unregulated as a private road, is in fact already compromised, and this would add to that. So I urge the board not to support this request. Also, at a minimum, if you are going to continue to consider it, I don't see how you could properly evaluate the application without an existing condition survey that does show there's a transformer on one corner. There are some very tall pine trees. There is vegetation there, all of which would have to be removed. The plan that you have doesn't even show where the driveway is right now. Sure, there's some photos, but that should not be the standard that the planning board of the town of Nantucket requires for the issuance of a special permit. Thank you.
Thank you, Art. Anybody with questions to Art? John?
Madam Chair, I couldn't have said it any better. I agree wholeheartedly with Art. I feel like with the I know what was existing, what is there. So they're not proposing anything more than what they're using. But as Art said, they're not in compliance. So in essence, we're rewarding them. The building is not built that they plan to construct in the back. So what we're saying is you don't have to be in compliance. Then we'll give you the compliance so to make it easier for you to build the duplex in the back. If the duplex in the back was restricted to covenant or affordability or something like that, then maybe that would give me some kind of reasoning or justification to maybe do this waiver. So it would affect future people on the street or in the area from doing the same thing, because I think Art hit it on the head. This I foresee this when you go down Marianne Lane, or you go down Macy, or you go down somewhere else. This will be the example of what we approved for future curb cuts. And because someone is out of compliance, I don't think we should be rewarding them, because I see this going to happen more. Plus, we're really saying that, you know, it's safe to load out that street and then back out. It might as well be parking on both sides of the streets the time we get done with this. So the building has not been constructed yet in the back. So if this is a way they can still have the ground cover, so they can still build what they want to, but they're not going to be able to make it into a separate duplex. They can actually build and under the regulations of the required parking for the bedrooms. So I'm really opposed to this. Sorry.
Thanks, John. Megan, is there anybody else who want to speak from the public?
No, I'm not seeing any other hands raised.
Okay, are you ready to close the public hearing?
So moved.
Fritz moved. Is there a second?
Second.
Nat seconded. Roll call, Fritz.
Aye.
Nat.
Aye. Aye.
Dave.
Aye.
John.
Aye.
Judith. Aye. Okay, further discussion. John, passionate as always.
I said all I could say.
All right. Other comments?
I'm sure I think I have to agree with John. I mean, I look at the photos, I look at the drawing, the original, or not, whatever it is, the plan we got. I mean, I don't even know how they build the structure in the back, other than perhaps through adjacent property. But I just I don't think I can get myself to be comfortable with the findings that we would have to make to permit this.
Thank you. Nat, Dave Callahan.
No. Go ahead.
Go ahead, Nat.
Just, you know, I mean, I kind of just, you hear me moaning and kind of sighing, you know, because this is, you know, part of this area that it's not, even if we deny this, there's still going to be things that are, you know, subject to the existing conditions of this area. You know, I understand both sides of this. You know, it used to be denser zoning, now it's less, but it still allows a lot. And, you know, people need to maximize the mixed use, and that's the key. It's in order to, you know, work from home and have your business at home or whatever the case may be. So it's a struggle, you know, and also the way the buildings were laid out originally doesn't take into consideration the future needs and the future permitting that would be needed to maximize it. So this is where they're stuck with that. So so that's all I have, you know, it's just unfortunate.
Dave.
I mean, listen, I think Art and John are spot on here. I think that we're just in a rock and a hard place. If you drive down that road right now and see how people are parked, it's a disaster. So whether we permit it or not, people are going to be parked up on lawns, up against the road, every which way in that neighborhood. So I'm not clear what the right path is. To add another structure in the back that takes up, that'll need more parking is not the answer either. So I don't know. This is a tough one.
Dave Callahan, did you have anything you want to add?
I agree with Don. I just think, you know, we can't reward the bad behavior. It's a tough spot in the neighborhood there, but I think allowing more building in separate dwellings is just not the right way to proceed there. So if I was voting, which I'm not, I'd vote against it.
Thank you. Is there a motion?
Make a motion to deny.
John moved to deny, and who seconded Nat?
Fritz.
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 Okay, roll call vote. Fritz,
Aye.
Nat,
Aye.
Dave Iverson. Dave Iverson.
Dave. Yeah.
I'm not, you can't hear you. Can you not hear me?
I couldn't hear
Got you
you. I'm
now.
sorry.
Okay, aye.
John Trudell.
Aye.
Judith, aye. Thanks for your efforts, Brooke. We know you took another shot at it and appreciate it, but I think you hear what the concerns are. So
There seems to be consensus here.
I think so.
All right. Thank you
Okay.
all. Have a good evening.
You too. Okay. Everybody's still doing okay? Do you need a break? It's 2 hours in. We're doing pretty well here.
Yeah. I think we should keep going, Judith, unless anyone has to
If
take
you
a
need
break.
a quick break, go right ahead. PLSP 2020-09-69, Naughty Cal LLC, 26B Daffodil Lane. Mark Poor, there you are. Megan, do you
Greetings.
want to warm us up before Mr. Poor speaks?
Sure. So if you recall at the last meeting, there was, we didn't even really get into should we or shouldn't we approve. It was more the question of whether or not these two units were held in common ownership. I've reached out to Mark and he's supplied you all with the master deed and the exclusive use areas. The condos are eligible to be held in separate ownerships. It just so happens the same entity holds both. So I think I'll hand it over to Mark and he can kind of explain further for you.
Thank you. Hi, Mr. Poor.
Thank you for hearing me. As
here.
Megan said, both units are held in common ownership. And the owner of Unit 1 and Unit 2 is expressly interested in separating the driveway component so that each unit has its own driveway access and its own parking to accommodate their needs. The current master deed that is on record from 2014 shows a proposed driveway that would access the current parking on Unit 1, which the owner of both units wants to abandon in favor of the proposal in front of you that shows the parking access from Daffodil Lane and left onto the boundary of that property shown in the plans. So that in fact, they are only impacting the placement of the proposed driveway and no other component of the master deed by the proposed alteration of the site. And simply by this matter of adjusting the location, they understand that they will have to amend the master deed if the planning board is recommending approval of the proposed alterations to Unit 1 common area.
Okay, board members, do you have a question for Mr. Poor? Otherwise, we should open the public hearing. Let's open the public hearing. Anybody who would like to speak on this matter, please use the chat and raise your virtual hand and Megan will let us know so we can call on you. Anybody out there?
Yep. So we have Henry Sanford.
Hi, Mr. Sanford.
Henry, I think you need to unmute yourself.
Hello? Hey, sorry, I missed that. I'm in dinner mode with the kids. You guys
No,
talking about the
welcome to the meeting and welcome to your kids. Thanks.
yeah, thank you, guys.
Civics in action, kids.
Yeah. I'm just here to listen to you guys about the Act Now letter.
Oh, you raised your hand, Henry, for this public hearing for Daffodil.
Okay, sorry, my kid. I'll lower the hand. Jackson lowered his hand, raised his hand. Sorry.
That's okay.
Well, tell him we take young commenters too. So that's at the tail end. I'd guess it's another hour if he may want some more Cheerios or pizza or whatever's for dinner first. Okay, anybody else? This is on 26B Daffodil Lane. Not to worry, Mr. Sanford.
Proposed driveway.
Okay, if there's nobody, shall we close the public hearing?
Yeah, motion to close.
Thanks, Nat. Second.
Second.
John seconds. Roll call. Nat.
Aye.
Dave. Dave Iverson.
Aye.
Aye. John Trudell.
Aye.
Fritz.
Aye.
Judith. Aye. Okay, so let's see.
Thank you for your time.
Hold on here. So
Not over yet.
hold on till we've acted there, Mr. Poor, just to be sure we're all on the same.
Yeah, I just need just a teensy little bit of clarification from whoever's, this is all coming back to me now. I'm looking at this one of the page 18 is sort of telling me what happened at the last meeting. So can you just, the original common area where it says driveway common area, is that going away or is that staying?
Yeah, it's page 15, 16.
There is
Okay.
no adjustment to the common area. There is
Okay.
only an adjustment to the location of the proposed driveway and parking.
Okay, good. Just checking that new spot on the other pages. I see that. I'm just trying to, get back to where I was
Thank
before
you.
here. I got it.
So this is second driveway access, and we have to make findings, and then
Yeah.
the staff has suggested conditions.
It's good. Yep.
Further discussion from the board?
Just one question, Madam Chair. So
Yes, thanks.
with the second driveway and second property from the corner, are we in compliance with whatever the requirements are for distance from a corner?
Madam Chair, through you.
Yes.
The distance required is 25 feet, so that is in compliance.
Yeah, it's further than that for sure.
Yeah.
Yeah.
Okay.
Thanks for clarifying, make it.
Normally curb cuts will take as a case-by-case basis. This particular area has a lot of co-ops. So there once were single lots that have been, sold separately. And I don't think this is out of the ordinary. And because of the safety of, around curves, I think this is actually a pretty good plan.
Yeah, I agree. Agreed.
John, you want to make that a motion?
Sure. I'll make a motion to approve with the findings, the 3 findings. If I don't need to read them, I won't. And then also with the 4 staff recommendations.
Yep, I'll second that.
Nat seconds. Is there further discussion? I think we closed the public hearing, I'm pretty sure, right?
Yes.
Yes. Henry's kids closed it.
Yes. You ready to vote, everybody? Okay, Nat,
Aye.
Dave Iverson,
Aye.
Fritz,
Aye.
John,
Aye.
Judith, aye. Okay, thank you, Mr. Porter.
Thank you and happy Thanksgiving.
Thank you.
Same to you, Mark.
Next is PLSP 2020-76, Curran D. Huser, 69 Surfside Road. Brian Swain, I think I saw you before. Are
Yeah.
you still there? What?
Good evening, Madam Chair.
Hi, how are you?
Wonderful. How are you?
Good. We
Okay,
like
well-
your backdrop. Looks like a real office there.
Well, thank you.
Wow, I didn't know he had his name on the paper now.
Nad, I can get you this background too if you want. Well, thanks for the time tonight. I think you may have seen in the staff report that due to a revision to the plan, we unfortunately have to carry this one over because
Yes.
we've requested a parking waiver, and due to the notification requirements, it can't be heard until next meeting. So I think this would be a great opportunity to sort of work through the application and get some general feedback and see, ultimately if the board would be open to the parking waiver. So Curran Heiser, he's the owner of 69 Surfside Road. That's a 10,000 square foot parcel located in the C-Tech zoning district. As you'll see on Exhibit A, it's improved right now with a single family dwelling that contains approximately 888 square feet. And there's 2 sheds. And, as I said earlier, he's the proud owner of the local moving company, Your Friend with a Truck. And as you may recall, we were before this board in 2018, approximately 2 years ago. He applied for and was granted a special permit to construct a 1,680 square foot storage garage on the premises. His business has taken off and he hasn't constructed the garage yet, and he desires to construct a larger structure. And that you'll see on is Exhibit C and D, which are the MCD plan and the HDC elevations that he submitted. And in summary, it's a 3-story storage barn. It contains approximately 2,161 square feet of ground cover. And the aggregate total interior area is approximately 5,340 square feet. And on the first floor, there's about 1,240 square feet of storage and warehousing with a loading zone, some office space, and a break room. The second floor contains approximately 1,571 square feet of storage and warehousing, again, with a little small office and a little workshop there. And on the third floor, there's approximately 1,700 square feet of storage and warehousing. And because the aggregate interior commercial storage and warehousing is over 4,000 square feet, it triggers the MCD requirements. So tonight we're here seeking relief. Was there a question? No.
I think he's just affirming that he's following you.
Okay.
Yep.
So we're here seeking relief under 13911, the MCD chapter. We're seeking a waiver of the traffic study under 13923B2B. We don't need an open space waiver because that was confirmed with the revised plan. So we're not here for that, but we are here for a parking waiver, which, as I said earlier, will be heard next month. And as you are aware, there are certain conditions that the board has the discretion to impose with an MCD, such as the landscaping, a signage plan, a lighting plan, and certain conditions related to utilities. And this house has all its utilities underground currently. The applicant desires to have standard downward lighting, nothing extravagant, because he does live across from where this proposed structure is to be located. And when he goes to build it, he intends to restore it to its current condition with grass. So we're requesting that there not be a landscaping plan because he just, after it's built, he just wants to restore it to what it is now. And if there were any signs, those would be approved by the HDC when the structure gets the certificate of appropriateness. And I think that the HDC could come up with a plan that would be fitting with that neighborhood. So we're asking to not submit a sign plan. The proposed hours of operation are Monday through Saturday, 6 days a week, 8 a.m. to 6 p.m. And like the use that was approved in the existing special permit, this is going to be a private storage facility. It won't be open to the general public. Only your friend with a truck employees will be allowed in the structure. Any goods going into or coming out of it will be handled by the applicant's employees. The inclusionary housing unit I don't feel is necessary because the applicant owns this property and there's already a existing single family dwelling on the same parcel of land, and that's where the applicant lives and resides. And in terms of the parking waiver, he's required to provide 6 spaces, and we're able to show 1 handicap spot, 3 conforming parking spaces, and then a spot in the loading zone. So he can provide 5 right now, and we're seeking a waiver of that 1 spot because he's required 6 spaces. And Leo Azadorian, I believe, is here, and he can answer any engineering questions you may have. I'd be happy to answer any other questions.
Board members, questions? I have one, Mr. Swain, if you don't mind. One of the things you're asking is a waiver of a traffic study. I don't think you specifically explained why, other than probably that was reviewed when you had the prior submission to us not that long ago. But is there anything about maneuvering trucks in and out of there, anything that we should know about determining whether to authorize that?
Sure. So, it's kind of at the corner of Surfside Drive and Surfside Road, where it comes off Surfside heading from the intersection towards the beach. And there's a little turnoff that goes downhill, and it's a hammerhead dead end. So, the only people that go up and down that road are the people who reside off it or have a business off it. So I didn't think it'd be necessary to have a traffic study for a traveled way that, is very infrequently used.
Okay, we just need to have that on the record just to be sure. If we ever have to come back to this, we know why we did what we did.
I get it.
Madam Chair?
Yes, done.
Just a question for Brian. The maintenance of the road. I know the road you're speaking of, and I know there are a couple of residents there when you go down the road to the right. Has there been, number one, any opposition from any of the neighbors? Are they in support of this, or you just don't know if there is or isn't? And number two, because the use of the truck with the storage now, I suspect there's going to be just a little bit more traffic, and I know that it's a dirt road, it's not a paved road, so I would want any of the neighbors or future neighbors to know that the commercial traffic going through there, the road would be at least properly maintained if there's any damage to it. So those are 2 of the questions I have. And I know that we've had storage units come up before us before, and some were met with opposition. Some were in commercial industrial areas. I'm glad to see that this is private, not public, because I think we would have a lot more restrictions that would be put on it. And really, the road is a big thing for me for the future, because although you might know the neighbors right now, you might not know who the neighbors are going to be later. And I would just want to protect their rights with the traffic that goes through it.
Sure. And I think, I guess to answer your first question, it's part of a homeowners association, I believe. And I think the association has the obligation to maintain it. And my client would definitely do his part and, be a good neighbor if anything was coming up that, he was causing additional wear and tear. I'm sure, he'd do the right thing and maintain it. I think it's part dirt and part tar. When you come off the turn from Surfside and you head down into the road, I think there's not an apron, but there's a portion of it that's that's in good shape right now. And what was your second question, John? Sorry.
No, that was pretty much it. Opposition, any neighbors, it sounds like if they're part of the association, we would have heard or gotten letters or something, but I was just wondering if you had any opposition to that.
No, I think he has a great relationship with all the abutters, and I think they may be the same ones that owned the property 2 years ago when this was, sent out, noticed, and applied for when the first special permit was heard. And there was no opposition then, so I don't think he's had any opposition related to this particular application.
Thank you.
Other board members, then I'm going to open the public hearing knowing that it's going to need to remain open so that the parking waiver issue can be considered again. Members of the public, if anybody'd like to speak on this matter, there'll be a chance at our subsequent meeting also, but if you're here expecting to speak to this tonight, we would be happy to have you do that. Just use the raise hand function in the chat and Megan will let us know and we can call on you.
So we have Vicky Folger with her hand raised.
Okay, Ms. Folger.
I don't know if you can hear me at this point. Hello?
Yes.
Okay.
Yes.
Okay, good. I just have 3 questions. My first question is if there would be any impact on the wetland, and if there is, how that would be dealt with. My second question is what will be stored there? Is it just furniture and appliances and that type of thing? Or is there a possibility of chemicals being stored? And my last question is, we are a little confused about the property line. We are at 4 Valley View Drive, and we're not sure if we're abutters or not. And that's it. Thank you for the opportunity to speak.
Thank you, Ms. Folger.
I can first say that there's no intention to store chemicals there. The engineering, I don't know if Leo's still connected, but I believe this is, outside the Concom's jurisdiction. And I think as indicated in Ed's report, he didn't see any adverse effects on the abutting wetland. And what was your third question?
A butter to that 4 Valley View.
It was about the property lines, if she's in a butter. Megan may know that.
Yeah, I'm looking at I'm going to pull up the GIS. Give me just a moment.
Madam Chair, is there a
yes
whether or not she's on a butter?
Megan's checking the
I don't see her on the list. Oh, yep.
My question was simply, is there a significance?
Other than getting notice, I mean, no, I think she's entitled to raise questions. I think it was more for her own interest, trying to understand where the property was perhaps or something like that.
Yeah, so she's a direct abutter, kind of on the left hand or below on the left hand side. So an abutter to an abutter, she's right beside 69R. But Catherine confirmed she was on the notified list.
I hope, Ms. Folger, if you're still there, that we answered your questions, but I'd entertain a motion to continue the public hearing since we'll be looking at the parking waiver question in December. So if there's more questions, Ms. Folger or anybody else, you could come back. Is there a motion to continue?
Motion to continue.
Okay, John moved, Fritz seconded. Roll call, John.
Aye.
Dave Iverson. You're mute, Dave.
Aye.
Nat.
Aye.
Fritz,
Aye.
Judith, aye. Other comments to Mr. Swain now or questions so he can take them into account before he comes back next month? I would just say your client, I think, is well regarded generally and is providing a good service to the community. So I'm not surprised there's not a lot of unease about how they operate, because they probably do a good job with their property too.
Great, thank you.
Okay, so shall we continue this matter until the December meeting? I guess we need another. We continued the hearing. Do we need to continue the matter in addition, or is it enough to continue the hearing?
No, I think you're covered with the motion that was.
Okay. Okay, Mr. Swain, thank you.
Great, thank you so much.
Okay. Next up is PLSP 2020-10-80, Isaiah Truman, 117 Orange Street. And yeah, let's see, who is Jay Moroni, you're representing the applicant. Welcome. Megan, do you want to do a quick overview, and then Mr. Moroni can step up if he'd like?
Sure. So the applicant's requesting a special permit here for a recreational facility. Currently, the site is utilized for personal trainings, which falls under personal services. That's a use allowed by right in the CMI zoning district, whereas a recreational facility requires a special permit. They do want to continue to offer personal training services, but want to expand upon that by creating a year-round athletic club that will prompt creating the use to convert, getting tongue-tied here, that will prompt changing the use to the recreational facility. They'll make some modifications to the interior of the structure, which is about 1,500 square feet of ground cover. They're proposing to have 5 weight stations, a treatment room, 6 cardio stations, and 2 restrooms. They're proposing an occupancy limited to 11 people, 11 patrons and 4 employees, so a total of 15 individuals with 5 parking spaces required. I think then now would be a good time to pass over to Jay to expand upon their actual business model, kind of things that they're encouraging about public transportation, hours of operations, and the like.
Thank you, Mr. Moroni.
Thank you, Madam Chairman, and thank you, Megan, for your always excellent introductions. I appreciate it very much. I think just basically what Megan said holds true. It's a slight change in the business model from personal training solely to being a recreational facility, but the business model actually largely remains fairly constant. It's going to have a very focused on the personal training with low coach to client ratios. So the building will rarely, if ever, be at the maximum capacity of the 11 clients and 4 staff. The building has 8 parking spaces where 5 are going to be required, and applicant will put out 2 large bike and scooter racks and provide bus passes to employees. Utilities are already provided with sewer and water, and there's an on-site dumpster and laundry on the premises currently. Pending your questions.
Mr. Moroni, we had correspondence from Mr. Donato, asked several things such as the type of equipment, whether there'll be sound buffering, whether there'll be activities out in the parking area outside. You probably have that correspondence too. I wonder if you could address those questions.
Yes, ma'am. So from the questions, I'll take them backwards forward. They currently are using the parking area for some outdoor work with clients, And I think Mr. Donato was concerned about using the yard, the front yard on Orange Street. There's absolutely no plan to use that front lawn space for clients. The back area with the parking lot is more than sufficient and is more likely to be, a better area anyway for working with clients. It's more of a stable surface rather than grass. The lawn in the front is actually fairly small. And so the answer to that is no, there's no plan to expand into that area. His other question was about going into like group classes, like spin or Peloton. That's also not in the, contemplated in the business model. Like I said earlier, really the goal is to provide very low client to coach personal training, very hands-on, that doesn't really lend itself to doing like spin and Peloton. So that's not an area that there's currently a discussion of expanding into. And then his last point was about hours. What we've requested is, ma'am?
I just coughed a minute to get drink of water. Sorry.
Oh, it's quite all right. Sorry, I'm just on a phone. I can't. Anyway, what we've requested is operating hours of 6 to 8 p.m. Though there is a desire to that be operating hours, but to have members be allowed access to the space outside of that time to just do like a workout on their own, and that would not be large numbers by any stretch of the imagination, or necessarily particularly frequent, but just to provide people who need that flexibility for their ability to get their training in and get do their workouts, that they have a access code that allows them to come in. The premises are monitored through that entry software, and also through video surveillance.
I just think it may be important to be clear about what hours of operation actually means. So maybe that's something we need to come back to further, but let me see if there's others who'd like to raise questions. Board members, initial thoughts, and then we'll go to the hearing. John?
Yeah, question for Jay through you, Madam Chair. Jay, just from the parking standpoint, I know this summer was very different with COVID. I know Fast Forward closed the facility there, and they mainly use the out-of-town one, but I understand they're not going to reopen there. So with respect to the parking, I know you have the required 5 spaces, but I think that's considered an open parking. And how would that work if another business went in there, if you're going to be using the outdoor parking for training?
Yeah, I mean, I think my understanding is that the premises has access through easements to 8 spaces. 5 are required here. The outdoor training and working in the parking lot is not something that we're necessarily requesting as part of the special permit. It's just something that was possible now. It's something that we'd like to keep doing. If depending on, you don't need that much space to work out with one person out of doors necessarily. I mean, there's lots of ways you can make it work. And one of the things that I think the applicant is really pushing is that because we're working, they have a coach with an athlete and they're working out, that it can be tailored to the environment that they're in and to the needs of the client. So if another business has moved in there and that, the parking is what the parking is, that's something that can be flexible. It's not that, the applicant is looking to have that entire parking area, roped off and made into an outdoor gym. It's that we can take a person outside and do lunges down part of the parking area to give them, a different workout experience. But it's not necessarily required or part of the application itself per se.
Right. And I guess one of my comments is really in respect to the parking that happened this summer. Understandably, you can utilize that space since nobody was at Fast Forward. But we did notice that, and we had some complaints from people. There was a through way there, and they were coned off and blocked because there wasn't Fast Forward. So that really cut that down. And I'm just looking to establish something now so that it doesn't hinder future business in that facility there, so that you can't put up cones to block off the parking where that might really impede on someone's business that is unrelated to yours, because it is an open concept plan, and I don't want you to utilize that on your own and not necessarily share it by blocking off that entrance. Also, it becomes a safety issue where here we are as a planning board giving approval for this, and then it's opened and you're training and somebody makes a left-hand turn and hits one of your the clients that are training. It doesn't seem like it's a safe way to condone training in the parking or the thoroughfare there.
I understand what you're saying, and I think that the use of the parking area is not crucial to the granting of the special permit for the facility. And if the planning board wants the parking only used as parking and to limit use, you can put conditions on, but we think that allowing some flexibility to be good neighbors and to use that space to provide people with more opportunities to work out and be healthy. Obviously we all love Nantucket and being outside during those months that we can be outside. And what we're looking to do with that space is, if possible, and it's reasonable to have that be a tool in the toolbox, that's nice to do, but we're not turning it into a group class area or saying it's anything other than parking.
Yeah, thank you.
Other board members, Fritz?
I'm just inquiring a little bit. So this is leased property, not owned property. Am I correct?
No, sir. Since the application went in, the applicant has purchased the building.
Okay. The next question would be, since I think we're all familiar with the property, the so-called Fast Forward building, is that owned by the same person, or is that owned by somebody else?
It's owned by somebody else.
Okay. So then what controls the parking use on that now jointly owned property?
That's what I was trying to bring up, Fritz, the shared parking.
Fritz is asking my question.
We have the authority to decide, and what is in the hands of somebody else. I mean, I don't want to be granting something or restricting something if it's not really within our legal right to do it. So anyway, so I think we need to understand that.
Well, there's the property at 117 Orange is purchased with easements, giving it basically 8 parking spaces in that shared lot. Those parking spaces go to 117. What we're applying for is for use of the building as a recreational facility. We're not applying for the parking area to be a recreational facility. They just happened to, in the summer, since the parking spaces were open and not being used, they used them outside. But that's not what we're requesting in this application.
Okay, so let me just step back. I think you said 8 parking spaces and easement. does that mean that the owner of the other building has any rights in those 8 spaces? Is it shared parking?
Open parking, I
Mine?
believe.
Sorry.
I believe they were open parking. So even though you have access to 8 spots, they're not designated spots. They're incorporated in the overall parking on both sides. So it's really open parking, if I'm not mistaken.
Yeah, I believe that's right. We have access to the 8 and we have a requirement of 5.
Mhm.
But again, I don't want us to get wrapped around the axle on people working out outside, because that's not anywhere in our application of what we're asking for.
Right.
We're
And if
asking,
we leave out that, Jay, I think if we leave out the parking issue, then we can just concentrate on what you're applying for, and that's with the recreational use inside the building, and I'm okay with that.
Thank you.
thank you.
I think we got it.
Nat, were you?
No, just a quick run through. Fritz asked all my questions for me. I can't believe that. That was like verbatim what I was going to ask. But I would just say that to everyone, just, this used to be the movie place. There was way more cars in and out. The Fast Forward was busy then. Cumberland Farms was the other Cumberland before it was the new one. And I think it's more about what works like it always has, I guess, would be my thing. And I think that this particular arrangement is sort of like a restaurant allowed to eat outside right now because the other place is closed and they don't really have that right, but they're doing it just because. So I don't have a big issue with that. I just think that we just have to be aware, Jay, of what's going to happen to Fast Forward later a little bit. I think Cumberland works pretty well. If there was that angled parking like there used to be, it would probably be a little bit more of a question, but I think it's kind of flushed itself out over the last few years. So I don't have an issue with this plan. So
Question.
Fritz.
And this is to Leslie or staff. So we had single ownership, I believe, of 2 businesses operating with 8 parking spaces. That now gets divided and you have 8 shared undesignated parking spaces. Does that satisfy the parking requirements for whatever's going on there?
I believe in your staff report, or maybe it was in the application packet, that there are 6 required parking, 5 required parking spaces. And I don't have those old decisions handy. I wish we would have put them in your packet, but I did review them recently, not for this application, but for a concept at Fast Forward. And my recollection is that Fast Forward building, has 3 spaces. So if there are 8 shared and they have 3, that would leave 5 for this. So I think that works.
Okay.
Okay, I'm going to open the public hearing for anybody who's not done this before. Please use the chat function and raise your hand. Megan will let us know and then we'll call on you and we'll ask you to unmute and offer your comments. See anybody, Megan?
There's no one present with their hand raised.
Okay. Board members, are you ready to close? Leslie?
I just want to clarify a couple of things before you close the hearing. One, I think I heard that you would want to put in a condition, or that the applicant would agree to a condition about not using the front yard area for any sort of exterior activities. And then relative to the hours of operation, 6 a.m. to 8 p.m. for normal business, I guess. And then after that, there would be a key card. And I know that Mr. Donato was concerned about noise. And I don't know if lighting was in his letter or not, but I would just like to know how that would be controlled after 8 o'clock. Would people not have access to the sound system? How would that work? And is the board inclined to even entertain the 24-hour option? Because if you're not, then I guess how it works isn't important.
I think, Mr. Maroney, that was a question first to you, and then the board may want to offer thoughts.
Thank you, Madam Chair. Thank you, Leslie, for your questions and for your synopsis on the other piece of the yard. I think we'd be amenable to not having people allowed to use the sound system. I don't think that's something that we probably want people monkeying around with on their own anyway. People can use headphones. It's very common and pretty simple. So I think that answers Leslie's question on that.
And I think the other part was she wanted a confirmation that there would not be outside activity at the front of the property. I don't know, Leslie, if you were also wanting to get clarification about activity in the parking spaces.
I thought Jay was pretty clear about the parking spaces, that was something that happened this summer and isn't part of the application going forward.
But I just want to be sure we get that confirmed on the record. Board members, what do you think about the after hours access, I guess I can call it? Dave?
I mean, we're not exactly in New York City here. I just have a hard time believing that someplace like that would need to be open past 11. So I think that it's dangerous to give them permission to do 24 hours with a key card and not have control over the music, the stereo system, how many people come and go, and all the issues surrounding that.
I'd have to offer that I'd be worried about security and liability if somebody got attacked or, other kinds of factors like that. But I don't personally see how you can really enforce that functionally. And if it's available, it'll probably be used. But others have thought.
Boy, that's.
So, Dave, you were basically saying you would limit after hours access no later than 11.
Yes, I mean that would be my suggestion, I think. And just to backtrack a little bit, he has agreed no big group classes, right? He's not doing that's already been agreed upon, correct?
Yes, we don't have any, there's no plans for group or spin classes.
Okay.
Or just to get back to the chairman's point, there's no contemplation of classes in the front yard or anything in that area. It's,
Yep. Thank you.
Yeah. You'll have a lot of people getting into accidents if you do that.
It's a pretty small front yard.
He answered, did you get affirmation of things you had on your mind? If so, we can close the public hearing. If not, we need to nail it down a little bit further.
I think, can I just add to this night thing?
Yeah.
Just real quick, I agree with what Dave said. I didn't catch this. So somehow went over my head about this 24-hour idea. This is a special permit. We've never issued anything like this before that I can remember. It's certainly not in this sort of mixed, I know it's a CMI zoning, but it's residential mixed in sort of thing. So, he can come back. I mean, he can, we can see how this goes. We get no complaints. things sort of materialize over time and it kind of finds its own sort of level, he can come back and ask for, 1 in the morning or something. You know what I mean? So I'm not concerned in the sense of, limiting it until we see how this all works out. That's what the special permit is for. So,
Madam Chairman?
Yes.
Just in that vein, I think we'd be happy to accept Dave's limitation at 11 p.m. for now. And like Nat said, if we show that works, come back for different hours if there's interest by the members. In your deliberations, the only thing I would ask is that maybe just for the early birds, allow that pre-opening like 5 to 11 then, just to give the people who have to get to work at 8, give them time to get in there and get a workout in and get home and cleaned up and to work on time. A little buffer in the morning would be appreciated.
Can I ask though, how are you going to advertise this? Because on the one hand, I'm hearing something about its hours are, and on the other hand, I'm hearing that individuals can use it, but there won't be classes at that time. And I think that kind of ambiguity is a setup for a problem of misunderstanding later, honestly. Maybe I'm wrong on that.
Madam Chair, well, the way that the access system works is that they can cut off so that members won't be able to use their passcode to unlock the locks outside of whatever hours we set right now. And because of the way the business model works of a very high touch coach to member communication, that if the operating hours are 6 to 8, but access is 5 to 11, that's something that can easily be told to members. Word of mouth is that we're only booking classes 6 to 8, but you have access to the facility 5 to 11. I think that's less a issue necessarily maybe for the special permit and more a problem for having the applicant make their members aware of what's actually available to them. And so if we just limited the access to the members from 5 to 11, we'll make it work so that the members understand that that's what's available.
Okay, Leslie, did we get your questions answered?
Yes.
Okay, board members, are you ready to close the hearing?
So moved.
Second, sorry.
Okay, Fritz moved, Nat seconded. Roll call, Fritz.
Aye.
Nat.
Aye.
Dave.
Aye.
John.
Aye.
Okay, Judith, aye. So we're now to the merits of the decision.
Can I try a motion, or are you ready for that?
I was going to ask if anybody had last comments they wanted to offer, including David Callahan, if you had any.
Where'd you go?
No further comments. He was sitting down a minute ago, but okay. Just trying to be sure oh, there you are, David Callahan. If you have any comments, feel free to.
No, I had to get a phone charger, so that was my problem. But I missed a little bit, but I'd also like to make sure the windows are closed because I know they had them open all summer this time, and I'm sure.
I think they have mini splits there, so they're all set. AC.
David, you muted by mistake, I think. There you go.
All right. I'm good.
So David said, sure the windows are closed. Nat said they probably have mini splits, so they have AC.
Yeah,
Any
I think I saw them there.
on that, David?
But it doesn't mean they close the windows.
That's true.
But they can, a lot easier. Is Jay still there?
Yes, he's on the phone. You can't see
Oh.
his face.
You bet I'm
I
here.
see his name. Jay, they have mini splits there, right? I'm pretty sure I saw them there the other day. I was wandering around across the street, and I think I saw them.
Nice, but yeah.
I think so as well. And if you wanted to limit the decibel level when the windows are open or something, I mean, a little fresh air never, it's kind of nice when you're being healthy.
Yeah, as long as they're not cranking music late at night or at 5 a.m. or whatever.
I think for next.
Can I try a motion and see how it flies?
Okay, please, Fritz.
Comment.
Dave, you have a comment? I'm sorry.
Dave.
Yeah, just a quick one. I completely get the window thing, and they should be closed, but I think we should probably are going to need to give them a little leniency if we're still doing this COVID thing next summer. They're going to need to have some airflow through there to be a viable business. So and believe me, I don't want to see their sound spread, but I think we need to give them a little wiggle room for the first season, probably.
Leslie, is there a way, or Megan, to draft the decision such that there be a constraint on noise levels?
I'm actually working on a revision to the noise bylaw. That's not that easy of a task. So I would recommend you not putting anything in this particular decision. But I do think that you could include a condition, that says if there are complaints about noise, if there are complaints about lighting, for example, then you reserve the right to reopen the public hearing.
That sounds good. I think that satisfies everybody.
Yeah.
David Callahan, you had your hand up?
Nope. That wasn't me. No.
Okay. All right, Fritz was getting ready to.
Yeah, let me try this. So I would make a motion to approve a special permit for a recreational facility, subject of finding that the proposal is consistent with the purpose and intent of the bylaw, subject to the following conditions. One, hang on here. One, occupancy shall be limited to 11 members and 4 employees. 2, applicant agrees to supply NERDA parking passes to all employees. 3, provide 2 bike scooter racks on the site. 4, facility will be open from 5 a.m. until 11 p.m. but without but classes shall be limited to 6 a.m. until 8 p.m. Where am I? 5? Next one, whatever the number is. 5, I think. No utilization of the front yard for recreational facility for personal training, for training. 6, and here I was going to try to get to the issue of light and sound, and I was going to throw it back to staff, but I don't. So I'm kind of open to maybe the issue of on number 6, should we have any requirement, or what language should we use regarding light and sound? Help me on that one, or maybe.
Madam Chair, I would suggest that, the planning board reserves the right to reopen the public hearing and impose additional conditions, based on complaints of lighting or noise, something along those lines.
That sounds.
You also want to add something about the parking with the training in the parking to protect the future of the
Before
next
we
building.
move to parking, I see Megan's hand.
So, Madam Chair, through you, I think just to clarify 2 points that you are trying to make, Fritz. We can wrap in with what John's saying about the parking. Maybe we can say no utilization of the exterior spaces for training services, something to that effect. And then also, just because I think it could be a little bit conflicting, we may want to limit no large scale group classes and reword that while the facility remains open for access to members only between 5 a.m. and 11 p.m., the business is only open from 6 a.m. till 8 p.m.
Megan, I think that's exactly what I've said.
Yeah. Yeah.
So.
Meeting of mind.
Is the motion clear to everyone?
Yep. I'll second
Okay.
Fritz's motion.
All right, Fritz moved, Nat seconded. Further discussion? Roll call vote. Fritz,
Aye.
Nat,
Aye.
Dave,
Aye.
John,
Aye.
Judith, aye. Thank you, Mr. Maroney. Hope that clarifies everything that needed clarification.
Yes, Madam Chair. Thank you all very much. Thank you, Megan and Leslie.
Okay.
Thank you, Jay.
Now 7 o'clock. Do we need a brief break?
Nope.
Yes, no, yes. Nobody's moving. All right, we'll keep going. PLSP fund.
I'll hold up my hand if I need to.
Okay, well, seriously, it wouldn't hurt to take 5 minutes. We're doing well. The just so you know, the Cliff Road last item is continued, so we're forging ahead.
One more.
Well,
Good.
about a
Yeah.
5-minute stretch break, okay? I've got 4 minutes till 7, so about 3 minutes after 7, and we'll be back.
Madam Chairman, did you say Cliff Road was continued? It's not.
Yes, it is. 10A
Thank you.
and no, not your Cliff Road, Linda. 10A and 10B Cliff Road.
Okay, because I know there's a couple of Cliff Roads. What is continued though is 18 Essex to the next meeting.
Then, anyway, we're taking a 7-minute stretch break. If this were the 7th inning, you have 7 minutes to do what you want to do.
Okay.
Okay, Megan and Leslie, are you around yet? Hi. Catherine's still here.
I'm here.
Okay, I think Leslie probably wouldn't mind if we get started. Resuming at 7:03. Thank you, everybody. Next up is PLSP 2020-10-81, Patricia May Barone, 11 Rudder Lane. Mr. Conley, thank you for being with us.
Thank you, Madam Chair.
Would you like Megan to do a brief overview and then you can step right up? Megan?
Sure. So the applicant is proposing to construct a secondary dwelling unit. This particular site is located within the R10L zoning district, which requires a special permit for the second dwelling. The reason why this particular site and subdivision was placed in the R10L zoning district was because the private deed restrictions of the subdivision expired. Some of the property owners like the limitation of density. So this was a good fit, requiring the board to review such things such as secondary dwellings. I think Mike then can maybe further talk about the proposal, or if you have any further questions, aside from the fact that it needs a special permit, it meets all the other requirements of the second dwelling as our usual applications do.
Thank you, Mr. Conley. Thanks for being with us.
Oh, thank you, Madam Chair. The applicants, Patricia Barone wants to build a secondary dwelling unit for her son, is the primary reason for this. And the reason we're here before you is because it is in the R10L limited use district. But it does, as Megan said, it meets all the requirements for a standard second dwelling.
Thank you. Board members, do you have questions? Yes, Dave.
And maybe Megan knows this, but I'm just wondering and Leslie might be a better one to explain this, what the whole circumstances were behind the zoning change and the R10L and how we got there.
Madam Chair, if I may, I don't know, I don't want to step on Leslie's, but I used to live in this neighborhood. I was right around the corner on Mizamas. This is Pine Valley. We were once zoned RC2 before Andrew came to our association and asked if we would consider a lighter zoning change to R10. Because we had a 30-year restriction provision on second dwellings, we had to go into the R10 L designation. So our 30-year expired, and that was, I think, expired in 2015. Since then, I believe there was one second dwelling across the street from where I used to live on 11 Mass with Cozera, I think was the name. The planning board at the time did approve that second dwelling. So that kind of sums up what we had when I lived there, and I moved out of there about 2 years ago. So hopefully that answered some of your questions, Dave.
Thank you.
I'm wrong,
Leslie, any other thoughts?
I'll just add in that this was one of the first subdivisions that we looked at when we started phasing out the RC2 and started developing the new districts. And what we found was that, you know, there were some areas like this that had private deed restrictions and other things in place that we didn't have, you know, a good zoning district that was equivalent. And that's how, you know, R10L and some of these others came into being.
Yeah, this was the incubator for that.
So if the idea was that it could well be permissible, but that there should be a special permit rather than as of right.
Yeah, and we thought with that, it would give the neighbors an opportunity for the public notice and to know what's happening in their area and to provide public comment instead of it being a by right use.
And can I add something, Leslie?
Yes,
Just so you have to clarify what I'm saying, Leslie. I believe that the original deed restrictions allowed a garage apartment, not a technical second dwelling. And, you know, 30 years ago, I mean, 35 now, that there really isn't a difference. So that was I think that was also played into this a little bit. So, you know, every one of these lots could have been subdivided A&R with the old zoning. They're all over 100 feet of frontage. The lots are oversized. So this neighborhood has been saved from pretty much, you know, other than just a here and there, you know, growth, very slow. So that's a good thing.
Okay, Dave Callahan, you're okay. Anybody else want to speak? Otherwise, we'll open the public hearing. Ladies and gentlemen, if you're here for this matter, you just have to look at the bottom of your screen and you'll see a place for chat and raise your hand and Megan will let us know and we'll call on you. See anybody?
Emily Molden.
Emily Molden.
Thank you, Madam Chair and members of the board. I just wanted to make a couple of comments here and maybe ask a question for clarification as well. I certainly recognize that there's been a significant improvement in zoning in this neighborhood, moving it over from RC previously, but I also understand that the original subdivision permit by the planning board at the time included the condition that restricted second dwellings. That obviously had a statutory limitation at the time of 30 years, which has since expired. And it sounds like a lot of the neighborhood was really interested in maintaining that kind of lower density area and development. I'm interested in the ability of the residents there to have garage apartments. And I guess I was looking for some clarification as to how potential second dwellings could be combined on a lot with a garage apartment, if it's limited to one or the other, or if both could be applied for with a special permit. And then also just to sort of make a point that obviously there was concern from the neighborhood to maintain a lower density here. I know this obviously has been noticed, but I wonder if there's an active homeowners association, if there's a way to have additional or solicit additional input from the neighborhood moving forward on these. And Also, just to point out that this is within the Myacomet Pond watershed, which is important to keep in mind as far as considering future increased density and development here. So I just would ask the planning board to really consider those when considering whether or not to allow this. I think that you have the ability to maintain this lower density neighborhood that the original planning board had intended when they conditioned the permit, and that the neighborhood seemed to echo a desire for. Thank you.
Thank you. Megan?
Next up is Karen Dixon.
No, before, if you
Sorry.
don't mind, the question about Ms. Malden's initial question about are garage apartments also allowed in secondary dwellings? How does that all fit in? I just,
So a garage apartment can be a secondary dwelling. You can't have both unless tertiary is allowed. But in this case, the garage apartment would be applied for as a secondary dwelling.
and in terms of the usual notice was given to anybody who were butters, right? So,
yes.
Okay. And we take to heart the comments about Myacomet watershed. Okay, who's next, Megan?
Karen Dixon.
Ms. Dixon, welcome.
It's showing that you're still muted, and I don't have a way to unmute you.
Hi, Ms. Dixon. I think you're unmuted now. Can you speak so we can tell if you're unmuted?
Hi, my name is Jerry Berlin. Karen Dixon is my daughter. Is she checked in with you?
Karen Dixon is the name that it's registered under, but that's okay.
Did you want to speak, sir?
And negative. I don't think you are. We're here with reference to 2 Francis Street.
Oh,
and
okay.
Oh,
Sorry.
Well, sorry, it's going to be a while before we get to that. So hang in there and we'll be happy to see you again after a few more items we have to take up. That's very late in the agenda.
Understood, and thank you very much.
Thank you. Megan, anybody else?
No, not anybody else, but just through you. And I think Leslie would be able to further clarify this. But in our review discussion of this application, I do believe that the initial limitations on density at that time of the subdivision were put into place because of the sewer capacities of that time. So that played a huge factor in the allowance, or actually the determination of not allowing second dwellings at that point in time.
Also, through you, Madam Chair.
Yes.
I do know there is a very active homeowners association of which I was a part of, even though it's considered to be voluntary. I believe there's over 85% participation, and the restrictions had been lifted for over 5 years now, and there has not been a rush to look to add second dwellings. So I think the neighborhood at the time is comfortable with a special permit and giving each individual homeowner a chance to present their case.
Thank you. I don't know if anybody can address the Myacomet watershed situation. John, in a sense, you've touched on that by saying how much added development there was there, but we only can operate within the constraints of the bylaws that apply, right? So Leslie's nodding on that.
And I'll just point out that it is in the watershed, and the homeowners association worked with us on a rezoning that reduced the density by, over 50%. So we've already done a lot of work on that.
Okay, thank you. Seeing no one else, are we ready for a motion to close the public hearing?
Just one other question. We got no letters from any abutters, correct? One?
I believe there was one that should have been included in the packet.
I think I saw. All right, thank you.
Yep.
Okay, is there a motion to close the public hearing?
So moved.
Second.
Nat moves, John seconds, roll call vote. Nat,
Aye.
John,
Aye.
Is
Dave.
that mine? No.
No, me, sorry. Aye.
Fritz. Fritz, you're muted.
Aye.
Judith, aye. Okay, so the, someone ready to make a motion on the merits?
I'll make a motion to approve with the findings that the proposal is in harmony with the general purpose and intent of the bylaw, and two, that with staff recommendations, with the 6 staff recommendations.
Second.
Nat seconded, roll call vote. John,
Aye.
Nat,
Aye.
Dave,
Aye.
Fritz,
Aye.
Judith, aye. Okay, thank you very much, Mr. Conley, and
Thank you, Madam Chair.
good luck with that. Next is, I think, Ms. Williams, PLSP 2020-10-83, FHLP LLC 22 Cliff Road. This is about parking. Megan, do you want to kick it off?
Sure. So this request is requesting the board to waive the on-site turnaround requirement. That's a requirement for driveway accesses on Cliff Road. This particular site does not currently have an access. They're proposing just a singular off-street parking, compact parking space. It's very similar to the proposal you saw maybe about 2 months ago for 16 Pleasant Street. With that, planning staff's recommendations are to approve the request with the findings and conditions in the report.
Thank you, Ms. Williams.
Pretty simple. It's hard to turn around on those little lots up there. It's right next to another backing out, across the street, backing out some of them. The lots across the street are traditionally larger. They're the bigger lots right on the bluff. But a lot of the little houses on this side of the street all back out. 26 backs out, 24 doesn't anymore, but it used to when we rented it for 20 years. 22 backs out, and 20 backs out, and 18 backs out. So it's just in that little stretch there before you get to the fork in the road going down Cliff Road, and they just want to put a small space in there. It's gonna be a mini car, but it's a small space.
Okay, thank you.
They're fine.
I think I'll open the public hearing.
Oh, by the way, Madam Chair,
Yes.
the HDC has approved it.
Thank you.
With that, Madam Chair, I have a question for Linda.
Yes.
For you. Linda, when the HCC approved it, did they make any mention to the friendship stairs? I see that the left side of the friendship stairs kind of intrudes on the parking. Did they ask to cut that out and maybe just make entrance to the right side?
Yes, the original stairs did not extend to the left. The friendship stairs were added sometime after 1910.
So you'll be removing the left side?
Yes, they already approved moving the left side and just making it a one-way, which is what it would have been as a 3-bay.
Great, thank you. And also, I used to caretake this house many years ago. Is there still a window well as you go into the parking? Is something that you'd have to, it's not going to really affect us, but just keep in mind, is that?
Yeah, we talked about the window wells and the wall as well. We covered all that.
Great, thank you.
Okay, members of the public, if anybody would like to speak on this matter, here's your opportunity. Use the chat function to raise your hand. Megan, see anybody?
No.
Pretty quiet up there this time of year.
Okay. Are we ready to close the public hearing?
Move to close the public hearing.
Second.
John moved, Dave seconded, roll call. John,
Aye.
Dave,
Aye.
Nat,
Aye.
Fritz,
Aye.
Judith, aye. On the merits,
Make a motion to approve the application with the 3 findings and also the 2 staff recommendations.
thank you. Is there a second?
Second.
Nat seconds. Roll call, John,
Aye.
Dave,
Aye.
Nat,
Aye.
Fritz,
Aye.
Judith, aye.
Thank you very much.
Thank you.
One down, one to go.
Let's see, I think you're not next though, Linda. I think we've got another one in here. Arthur Reed, if you're still here, PLSP 2020-10-84, Richard P. Bodette, trustee of Westwood Nominee Trust, 8 Isabel's Way. This is the second driveway.
You may wonder why I'm representing Rick Bodette, who's perfectly capable of representing himself, but in fact, he is the trustee for the present owner of the property. I represented the former owner who sold it to the to Rick's client. And if you'd like, I can go ahead and
Yes.
Explain what we're trying to do.
Right ahead.
This relates to the fact that there are 2 driveways and have been for quite some time, 2 driveways on this lot. And we're obviously asking for approval of the second driveway and also the fact that there's no turnaround on the lot, which we consider to be unnecessary. It is in the Log 3 district. This involves a lot on Isabel's Way, which is a very little known road just south of the entrance to Sankaty Head Golf Course. And as you come in Isabel's Way, after you go into from Sankaty Road, you come, or Pulpus Road, whatever you call it at that point, you come to this property, which has a garage with a driveway and then a driveway near the main house, which is farther down the road. It's a dead-end road, and there's only one other property on it farther down, which belongs to the Sankaty Head Golf Club. The original house was built in 1981, I believe. The driveway for the garage was placed when the garage was built approximately 2001. So this has existed for almost 20 years without anybody being bothered by it. Again, the amount of traffic on this road is negligible. And what we're asking for is that the condition that's existed for all these years be ratified. There's no plan to do anything new with it as part of this application.
Thank you. Questions from the board? Otherwise, I'll open the public hearing.
I'm raising my hand as a member of the public if there's no board comment.
Okay, go right ahead, Linda.
I'm quite familiar with this property. I just did a warrant article for them, and it dead ends because it dead ends at basically what turns into the caddy camp eventually behind Burnell Street. So what's beyond it is Sankaty Head property. So there isn't any through traffic there. It is tight there. This driveway is pretty much a good place to turn around if you're trying to get out of there. There are only 2 other pieces of property that front on Sconset Road or Sankaty Road, whatever they call it these days. It's Pulpus Road, and to me. And so there isn't anywhere else to go. They own everything beyond the 2 that front on the main road. So there wouldn't be any impact, but this driveway is critical to that garage, and it was there before 2003. I know that. Thanks.
Thank you. Any other members of the public wish to be heard on this matter? Megan, any? Okay, is there a motion to close?
Madam Chair, before we close, just maybe Arthur can answer this. I have no objection with this, but I just, for clarification, we have 2 curb cuts, and I see down further down at the end of the lot, it appears that the road or goes into a driveway that almost looks like a 3rd curb cut. Even though it doesn't affect this particular lot at the end, it affects the caddy shack there, if you will. Just for filing purposes, it would be that you're just looking for approval for 2 curb cuts, not 3, correct?
Yes. I think that the driveway down at the end actually is a trespass on our property. I mean, we're not objecting to it. It doesn't bother us, but we're only asking for approval of the one for the driveway for the house and for the garage in the part of the lot over well to the east of that.
All right, thank you.
Thank you. Is there a motion to close public hearing?
Motion to close?
John, second. Do we have a second?
Oh, second, sorry.
Nat, seconds. Roll call vote. John,
Aye.
Nat,
Aye.
Dave, Fritz,
Aye.
Judith, aye. Okay, on the merits,
I'll make a motion to validate the request for a second driveway with the 3 findings that are stated.
thank you, John. Is there a second?
Second.
Dave seconded. Roll call vote. John,
Aye.
Dave,
Aye.
Nat,
Aye.
Fritz,
Aye.
Judith, aye. Okay, thank you, Linda.
Thank you very much.
Thank you, Arthur. Sorry. Thank you.
Well, I'll thank Linda then.
Okay. PLSP 2020-10-85 Nancy P. and Mayo F. Funderburg 55 Myacomet Avenue. This is yours also, Arthur.
Indeed it is. This is an application for a secondary residential lot special permit. The owners live in the house on the front part of the lot. It is proposed that there'll be a single driveway coming in. Actually, in order to reach the back part of the lot, there's going to be a portion of the existing house where I believe there's a garage that's going to be removed so that driveway access can be had to the back part of the lot. The owners plan to remain there as year-round residents and be able to sell the rear lot as the unrestricted lot. The lot that the owners will keep will be subject to a covenant at such time as it is put into separate ownership, and the decision should reflect that fact, and probably there should be something recorded so that it is on record that the residency covenant would be put in place when it's put into separate ownership. That's provided for in the bylaw. And other than that, it's your typical secondary residential lot subdivision.
Thank you.
We'll come in with an A&R plan as soon as this goes through.
Okay, thank you. Are there comments, questions from the board? Megan, any public comment?
I'm not seeing any.
Okay, then we're open to a motion to close the hearing and then a motion on the merits.
Motion to close.
John moved and Nat seconded. Roll call vote. John,
Aye.
Nat,
Aye.
Dave,
Aye.
Fritz,
Aye.
Judith, aye. On the merits, John,
Make a motion to approve a special permit to create a residential lot for year-round residents with the 1 finding and also the 4 staff recommendations.
thank you. Is there a second?
Second.
Nat seconded. Roll call. John,
Aye.
Nat,
Aye.
Dave,
Aye.
Fritz,
Aye.
Judith, aye. Okay, thank you. It's
Thank
worth
you.
being toward the end of the agenda because when we finally reach you, it goes more quickly, but you had both ends of the agenda tonight, Arthur. So
Supporting it at both ends, yes. Thank you.
okay, another Linda Williams, I believe. LSP 2020-10-86 to Mayflower LLC to Mayflower Circle.
Secondary lot for covenant. Pretty much it. we're okay with what Megan has put in there, except for 3 items, which I went over with Megan earlier today. If you go down on the, let's see, number 4 and number 5 aren't going to work because they're side-by-side parking on both lots and not front to back. So they're wider left to right than they are long. So that 15 feet doesn't work, as well as the 15 feet in width on number 5. Number 8, we've talked about adding 1 sentence to the backside of that, and I think Megan has the language for that one. Because we're dealing with an existing structures here.
Megan, do you want to speak to that first, or should we have the public hearing first?
No, that's fine. I can speak to that. I'm just trying to pull up a screen share so we can see the plan so you could better understand what it is that Linda is talking about here. Are you seeing the plan in front of you?
Yes, we are.
Okay. So I guess the second thing that she was going to address was the wording on the ground cover, the 12.5%. I'm just adding the phrase or otherwise allowed by the Zoning Board of Appeals, since they're the special permit granting authority, if one wishes to apply for a permit to exceed the ground cover. That's just a minor language change. Linda, this proposed driveway here is fine.
That's going to be narrowed. That has to be narrowed. We don't want to waste that much of it. See the stairs right to the bottom of that garage? They're coming off. So the parking is going to be straight in front of it, as far as I can tell from what she's saying to me, but it isn't going to be that wide. Let's face it. That's one big slab of concrete.
So you're doing 2 head-in parking spaces, because right now it's shell and it's not compliant.
Oh, it's concrete.
Okay.
So it's just going to be 2 head-in spaces there. Maybe 3 because of the garage apartment. 2 for the house, 1 for the garage, 1 bedroom garage apartment. So there may be 3 straight in, but they aren't going to be, it's not going to be 40 feet of pavement.
Do you need more time to process that, Megan?
No, I think, Leslie, if you could chime in here in terms of what would be allowed, I think my understanding would be that would require additional parking waiver to do anything more than the 2 head-in.
Except that it's been there for more than 10 years, so it's grandfathered. We just don't want 40 feet of pavement. So it's protected under the curative statute 6 up at the chapter 40A, but we don't
Linda,
want it that big.
Not when you're changing anything.
Okay, folks, I'm just going to try to get us back and focused here. If there's some debate here, it may be we need to carry it over till December. I think we need to give staff the opportunity to be sure they have the conditions match the requirements. Leslie?
I have to admit, I was addressing a different agenda matter when you all were talking about the parking, so I'm not prepared to chime in at the moment.
Let's see if there's any public comment first.
Seeing none.
Okay.
Madam Chairman, I think the issue that we're in here for is to separate the access. We'll work out how wide it can be and what the requirements are after that, but this right now it's to separate the access for each lot can have their own driveway.
I'm going to defer to staff about whether they need time to think this through and review it before we take action.
I think that it's a minor enough detail that we could work it out between the applicant as staff if you're receptive to the overall proposal.
Okay, are there questions, comments from the board?
Just a quick one on the small lot, on the covenant lot. It says maximum ground cover allowed 552.
Yes.
So that's all the the dwellings are already built. This is just getting switched, having a covenant. She's working with what she has, but I'm just saying, this is it for this lot. What we see in front of us, for the most
No.
part.
No, Madam Chairman, if I might answer that, the small structure on the covenant lot, it's an 8,000 square foot lot, so it's not that small.
That's what I
That
was
thing's
wondering.
going
It
away.
looked like, and it's in
going
our, what
away.
is this? Oh, okay. So they're gonna build a new build covenant,
Yeah,
Linda. Okay,
Yeah.
I got it. And this is in R20 out here? What is the zoning out here? I forgot.
or 12.5%.
Yeah, okay, that's what I thought. Okay. Very good, thank you.
Other questions, comments from the board? Are you ready to close the public hearing?
Oh, I see, existing 257, got it. All right.
Are we ready to close the public hearing?
Yeah, I think so. I'll make a motion to close, Madam Chair.
Thank you, Nat. Is there a second?
Second.
Dave seconds. Roll call. Nat,
Aye.
Dave,
Aye.
John,
Aye.
Fritz,
Aye.
Judith, aye.
As part of the motion, Madam Chairman, can we work out the details on number 4, number 5, and number 8 through staff?
I'm going to ask staff how they'd like to have that read, but I want to see who wants to make the motion first.
What was the numbers, 4, 5, and 8?
Yeah,
Okay. I'll make a motion to approve the secondary lot with staff recommendations 1, 2, 3, 6, 7, 9, and 10 as part of our approval. Now with 4, 5, and 8 to be worked out through staff for the approval. For the
Also
final
with the 3
approval.
findings, Nat.
And the 3 findings that the proposal advances the intent of the zoning bylaw by creating housing for year-round residents, that the second driveway access is not contrary to sound traffic and safety considerations, and that the second driveway access does not have an adverse impact on the scenic and historic integrity of the neighborhood.
I'll second Nat's motion.
Okay, Nat moved, John seconded. Is there any question or further matter to discuss? If not, roll call. Nat,
Aye.
Dave,
Aye.
John,
Aye.
Fritz,
Aye.
Judith, aye.
you have to do the A&R now, Madam Chairman.
Thanks.
Make a motion to endorse PLSUB 2020-11-00108.
Second.
Thanks, Nat. And John, was that you or?
Yes.
Okay, seconded. Roll call vote. Nat,
Aye.
Dave,
Aye.
John,
Aye.
Fritz,
Aye.
Judith, aye. Okay, I think that's it.
Thank you.
Okay,
Happy Thanksgiving, everybody.
you too.
Thank you.
You as well.
Leslie, is Essex Road, I'm sorry, or Megan, is Essex Road continued? Linda said it was, so that means, do we need a motion to continue it?
That's continued to December.
Okay, is there a motion to continue this item?
Motion to continue 2020-10-0082 till December 14th.
That's right, thanks,
I
Nat.
second.
John seconded. Roll call. Nat,
Aye.
Dave,
Aye.
John,
Aye.
Fritz,
Aye.
Judith, aye.
Happy Thanksgiving again.
All right. You sure?
I hope
Okay.
so.
Stay safe. I think we're down to PLSP 2020-10-87, Elizabeth B. Schwartz and James D. Feely, 3 Evergreen Way. If I haven't lost my sequence here. And Gasparo, that's yours, I believe, if you're still here.
Yes, Madam Chair. Before you tonight with two applications side by side for number 3 and number 5 Evergreen Way. They're essentially identical applications to divide each of the lots to create Nantucket housing need covenant lots in the rear with a common driveway access up the middle. And these lots will be served by town sewer as well. They're in the district. And I'd be happy to address questions or concerns that you may have.
Any questions to begin with? David Callahan? No? Okay. Let me open the public hearing. Are there citizens who'd like to speak to, I guess we'll take them one at a time, 3 Evergreen Way?
Not seeing anyone.
Okay, board, are you ready to close the hearing on that one?
Yes, so moved.
Thank you.
Second.
Dave or John?
Oh,
John.
second.
Roll call. Nat,
Aye.
Dave, Iverson,
Aye.
John,
Aye.
Fritz,
Aye.
Judith, aye. Motion on the merits, and then we have an A&R to approve also.
Make a motion to approve 3 Evergreen with the following findings: that the proposal advances the intent of the zoning bylaw by creating housing for year-round residents, and staff recommendations 2, 3, 4, 5, and 6.
Second.
Nat moved, John seconded. Roll call, please. Nat,
Aye.
Dave,
Aye.
John,
Aye.
Fritz,
Aye.
Judith, aye.
And then
Then
I'll make a
the
motion.
A&R.
Yeah, I'll make a motion to approve 2020-11-00105 A&R plan for 3 Evergreen.
Second.
Thank you. John seconded. Roll call. Nat,
Aye.
Dave,
Aye.
John,
Aye.
Fritz,
Aye.
Judith, aye. Thank you. Next one is PLSP 2020-10-88 Elizabeth E. Schwartz and James D. Feely, 5 Evergreen Way. And Art pretty much said this is the same set of issues. Megan, is there anybody out there wishing to speak?
Not seeing anyone.
Okay, is there a motion to close?
I'll make that motion.
Second.
Okay, Dave, did you make, I'm just changing the order to keep us all awake here. Dave Iverson. Aye. Nat.
Aye.
Fritz.
Aye.
John.
Aye.
Judith, aye. That was the motion to close. Now on the merits.
I'll make a motion to approve 2020-10-0088 with the findings that this proposal advances the intent of the zoning bylaw to create year-round housing for Nantucket residents, and items 2 through 6 for staff recommendations approval.
Second.
Nat moved, John seconded. Continuing to keep us awake, Fritz.
Aye.
Nat.
Aye.
Dave.
Aye.
John.
Aye.
Judith, aye. A&R.
Yeah, make a motion to endorse A&R 2020-11-00106.
Second.
Nat moved, John seconded. Roll call vote. Fritz.
Aye.
Nat.
Aye.
Dave.
Aye.
John.
Aye.
Judith, aye.
Thank you.
Okay, thank you, Art,
Thank you.
and happy Thanksgiving to you too.
Same to all of you.
He's still with us.
10,
One more.
He's got one more.
He's got one more. Oh, sorry. 10 and 12 Cliff Road is continued. Do we need to, they voluntarily requested that. Do we need to move to continue it, Megan?
I think just to be consistent, yeah.
Okay.
Yeah, I'll make a motion to continue 2020-10-0090 till December 14th or whenever they come back.
Thank you.
Second.
Nat moved, John seconded. Roll call, Fritz.
Aye.
Nat.
Aye.
Dave.
Aye.
John.
Aye.
Judith. Aye. Okay. PL SUB 2020-10-101 Lynn Berlin 2 Francis Street. I don't know if Karen Dixon or your dad are still out there. If you are, your moment is coming. Megan, do you want to do an overview and then we'll turn to Art?
Sure. So this is a 2 buildable lot AR subdivision being proposed. The site was subject to a zoning change, so there was a preliminary plan that everyone reviewed back in September.
Yeah.
So this AR subdivision is being applied for based upon the submission of that preliminary plan.
Okay, Art.
Yes, thank you very much, Madam Chair. As Megan said, we're proposing to divide this lot, which has 2 existing structures on it, into two lots. Both lots would exceed the minimum for the zoning district, with the rear lot actually being greater than twice the minimum allowable size for that district. And we're proposing to just use a small gravel road. This lot in this district wouldn't qualify for a rear lot subdivision. I figure that question may be coming up as to why that's not being done that way. And so we're proposing to follow the gravel specifications, and not all that much change from existing conditions. There's a gravel driveway that already runs down to that back garage, so we would do some improvements in order to meet current specifications. I did just last week receive Mr. Pesci's review, and we've already started working on that. I believe that we can meet all of his concerns, but I didn't want to try to rush that in just this week and have him have to review it. So we'll work on that, get that to him well in advance of your next meeting, and hopefully have his and staff's consent that we've met all concerns and anything else that you may have that might come up tonight. And as the chair mentioned, I do believe that the owner applicants are also in the attendee list.
Okay, Leslie, you turned on your light. Would you like to speak?
Not right now, no.
Not right now. Megan, are the Dixon family still out there?
I see them out there, but no one's raising their hand to participate.
Friends out there, if you would like to speak, this is your time to do so. From what I understand from Art, it sounds like we're going to continue this till the next meeting in December. So any remaining issues from the engineering report will be addressed when it comes up. Is that right, Art?
Yes, though if the board had any questions or concerns, I would appreciate hearing those to address those. Please.
I'm just wanted to make that clear to members of the public that we'll be continuing the public hearing if there's more they'd like to say later. Leslie.
I was going to make a comment on the rezoning, but I just realized I mixed this one up with a different one, so I don't have a comment anymore.
Okay.
Right. Yeah. Only concern I have, Art, is backing out. As long as we can turn around, I'm fine. That's the only issue.
We do have one member of the public with their hand raised to participate. Emily
Okay.
Mulder.
Thank you. Emily, welcome back.
Thank you, Madam Chair. I just wanted to ask a question because I had noticed one of the requests in the application was for an allowance of 3 dwellings per lot as opposed to 1. And I honestly am still not 100% familiar with approval required subdivision rules and regulations, but just given the location of this one and its proximity to the coast and flood zone, I just wasn't sure if maybe Art or the board wanted to just address that a little bit more as far as any concerns for increasing the number of dwellings. I think the ground cover is maybe 50% here anyway, but just speaking to that would be really helpful. Thank you.
Thank you. Art, do you want to comment? Could you comment?
Yes, thank you. I don't know that we would, especially on the front lot, actually be able to fit that. I just didn't think that there was, especially as we looked at the rear lot, any need to have a specific restriction on that, given that the lot was more than twice the minimum size for the zoning district.
So it's not that you affirmatively expect to put more there, it's that you don't see any reason to limit it.
That was the feeling. And of course, all construction would comply with building code requirements for the flood zone, and any alteration of land at all on this property is subject to review and approval of the Conservation Commission.
Thank you. Megan, I see your hand up.
No, Madam Chair, through you, just to further clarify on that, the RC zoning district only allows for primary and secondary dwellings, so a tertiary by default would not be an option.
So that doesn't have to be marked on the plan. It's just that's not possible.
It's not possible.
Madam Chair.
Yes, Fritz.
So I just need to understand, because I am concerned about the location of this property, especially the elevation. It's got to be in a FEMA flood zone. It's going to be in a bigger flood zone in the future. And so really my question is, are you anticipating any future building on this property?
There's none that I'm aware of right now, but I think we always have to anticipate future construction on any particular piece of property. And we have shown the flood on the existing conditions analysis plan. And the flood zone does, bisect this particular property. And like we say, any construction would need to meet those requirements essentially in terms of elevated and allowing floodwaters to pass through and those types of things, as well as be subject to, because not only is it the FEMA flood zone, but de facto becomes the wetland resource area regulated, known as land subject to coastal storm flowage. So we're subject to Conservation Commission review and approval for, as I said, any other alteration of land.
Yeah, and just an additional comment that I'll make, although we haven't taken any specific action on it, but, and I know you're aware of it, but the select board's adoption of the coastal resilience recommendation regarding taking into account future sea level rise in future building. And certainly that's something that I think we will or should be taking into consideration. And I know that the Conservation Commission is going to be. So this is exactly the kind of lot that coastal resilience would be concerned about seeing additional building on. I'll just leave it at that.
Thanks, Fritz. Others with comments for Art? Then I think what's in order is a motion to continue. Do you think, Art, you'll be ready by December, or
Yes,
you'll
ma'am.
need more than that?
No, I hope that will work.
So someone with a motion to continue till December 14th?
Make a motion to continue to December 14th.
Second,
Okay, John moved, Dave seconded, roll call vote. Dave,
aye.
Nat,
Aye.
Fritz,
Aye.
John,
Aye.
Judith, aye.
Thank
Okay, thank you. So we're getting to the end here. Are there public comments on matters not on the agenda? Then we've got another item of other business. Okay, the other business is, if I don't know if Henry Sanford is still out there, or his precocious child who's interested in civics. But this is the time if you choose to come back. Megan or Leslie, will you kind of walk us through the situation with the Act Now letter?
So there's a copy of a letter for, excuse me, a request for enforcement at 14 New Mill Street. This is in your packet for information only. It was addressed to Marcus Silverstein, the zoning compliance coordinator. In the letter, they are requesting that enforcement occur against a short-term rental, saying that it's in effect a commercial use in a residential area. So, you know, this is a new topic coming up this year. And, you know, in this particular case, the sole authority lies with the zoning enforcement officer to make a determination as to whether or not the use complies with our existing bylaw. So there's really no action for you to take on this letter. I think you all are aware by now that Act Now has submitted a citizen petition to regulate short-term rentals that was submitted as a general bylaw, not as a zoning bylaw. So the Finance Committee will be considering that article, you know, during the course of their public hearings, probably through the NPNEDC. You all will have an opportunity to decide to comment on that or not. But I think as a zoning matter, short-term rentals have a lot of other implications to the town and to the residents. There are financial implications and other things that are pretty far-reaching. And I would hope that, you know, as a policy matter, if there's some new direction to take on that, that would come down from the select board. So those are my comments.
Leslie, can I ask one kind of jurisdictional question? Insofar as I can imagine there could be an issue here about interpretation of the bylaws. That goes to ZBA rather than us, right? And do I remember correctly, they've had something akin to this earlier in the year, or some other town on the Cape did?
So the zoning enforcement officer is the first stop for a zoning interpretation. All of the building inspectors are zoning enforcement officers, and we have additional staff that are designated as zoning enforcement officers. So one of those people designated as such make a determination, and then that determination is appealable to the Zoning Board of Appeals. So there's no role for the planning board in making those determinations or participating in the appeals. Now, the one that was recently in front of the planning board, or excuse me, the zoning board, was an appeal of a determination made by the building commissioner about the use of a property for weddings and whether or not that was a commercial use. So in that case, the building commissioner, acting as the zoning enforcement officer, determined that it was not a commercial use. It was appealed to the zoning board. They agreed with his determination, and it's yet to be seen where that's going. That all just recently happened. So,
okay,
you know, we
thank
have
you.
our own bylaw that's different from the bylaws of other towns. So I think making a town to town comparison isn't always apples to apples.
Okay, thank you. Any other inquiries just for background that any member of the board wants to raise? Okay, so we are coming to the end of our sojourn together by Zoom in the virtual La La Land out here. Our next get together will be Monday, the 14th of December at 4 o'clock. Megan had sent out the schedule for the first 6 months of 2021. Won't it be wonderful to say 2021? Just so that everybody has that. And I think that's it, unless others have anything for the good and welfare done.
Yeah, Madam Chair, I'm sorry to go back one. I don't know if that was just a info, for the short-term rental tax with Act Now. If it was something that we were just supposed to hear about, that we didn't have any necessarily right as a planning board. It was just something, a statement that was going to be made. And I don't know if somebody or Act Now is looking for us to comment. And I have a lot to say, but I don't know if I state something, it shouldn't be taken from a position of the planning board. I would take a position from just a citizen. So I don't know if
John,
somebody.
I understood it just for our information, because we get information about things that may involve litigation or other things implicating areas in which we're regulating. So we actually told Julia Linder, she wrote to me and I sent it to Megan, and Megan wrote back to her and said, this is not an action item, and explained how ATM review works and that kind of thing, but it's not for action. If you feel like you want to hold forth, I'm sure we are always delighted to learn from your perspectives, but I'm afraid if we start down that path, we may be here a while.
Okay, well, then I'll reserve my comments for when it's appropriate.
Well, I think as Leslie said, those of you who can think back to the grad days pre-COVID may remember, I'm sure Nat knows this because he's chair, but NPEDC gets to comment on matters planning consideration or some language like that, even though they're not formally within the planning board's jurisdiction. So I'm sure that there'll be opportunities in that forum for comments, and
I'll save it for that.
I don't know. Okay. Again, just want to compliment our staff for all they've been doing to keep everything afloat here, and express our appreciation to you very, very much. I think we need a motion to adjourn.
Thank you very much as well.
Motion to adjourn.
Second.
Okay, roll call. John.
Aye.
Dave.
Aye.
Nat.
Aye.
Fritz.
Fritz wants to stay.
He's muted.
Fritz wants to stay. He raised his hand. I say aye too. Time for dinner, right? Okay. Thank you, folks.
Thank you, Judith.
Happy
Thanksgiving. Happy
Thanksgiving.
Thanksgiving,
Thank you.
everyone.
Happy Thanksgiving.
Thank you.
Be safe.
Bye. Be safe.
All right.
How do we fix this?